Right. Good morning, everybody. Thanks all for being here for this special meeting of the Evanston City Council. Clerk, would you please call the roll?
Councilmember Kelly.
Here.
Councilmember Braithwaite. Councilmember Nguyen.
Here.
Councilmember Newsma.
Here.
Councilmember Burns.
Here.
Councilmember Suffredin. Here. Councilmember Ravel.
Here.
Councilmember Reed.
Here.
Councilmember Fleming.
We have a quorum, which enables us to not do business this morning. No one has signed up for public comment, so we're ready to go right into our orientation, and so I'll pass the mic over to the city manager.
Thank you, Mayor, members of City Council. Today we are going to spend some time going through a lot of topics that are going to be relevant to you as you embark on your four-year term as council members for the City of Evanston. I appreciate you coming in today and giving us your time and attention. I think we have a pretty robust agenda, and I'm sure that you'll get a lot out of it. So with that, I'm going to introduce Dr. Gilo Logan, who is going to help us facilitate today, and welcome. Thank you.
Okay. Try this again. Good morning, everyone.
Good morning.
So I'm Dr. Gilo Kwesi Logan, and I serve as the president of Logan Consulting Services. I'm here. I am an Evanstonian, but I'm not here as an Evanstonian. So I just want you all to realize that. And I want to first congratulate all of you all for this role that you all are in. Some is new. Some of you all, it's old. But nonetheless, this is going to be a new year and a new council. So I want to congratulate you all, and on behalf of our entire city. And as we all know, you all are serving now. You're not running, right? So a fine distinction. And one of the most incredible cities that we live in is Evanston, Illinois. And you all are serving our community. And we just want to thank you on behalf of the entire community. And as we know, it's an incredible city, and it's going to be even more so due to your service to our community. So I'm simply here to facilitate the process today and for this two-part orientation, both today and for next week. And in between the two sessions, we're going to also do some team building for you all. So look out for an email coming at the beginning of the week. And though some of you all may not consider yourselves to be politicians, it's undeniable that you hold a political seat. And when we look at the word politics, partially it says the set of activities that are associated with making decisions in groups. And towards that end, while you all were sworn in this past Monday, there's a few words that really stand out that I just wanted to highlight very briefly. When you all took the Athenian oath of citizenship, it says we will ever strive for the ideals and sacred things of the city alone and above. The ideals, not the ideas, but the ideals. And when I think of ideals, I think of the standards. And the standards are going to be absolutely essential as you all grapple with very difficult issues, very difficult challenges that our city are faced with. And it's not just the ideas that you all have of your own, but the ideals. And I think it's really important to adhere to that. because that speaks to what's right and what's wrong, as opposed to what your opinion is of that. And then when Pastor Dillard, in his invocation, he said, among other things, we ask for a very special blessing of favor, strength, wisdom, and agreement. And I just want to underscore the word agreement. Agreement. And though you all obviously surely will not always agree, but it's important that you adhere to the standards when you disagree. And we see what's happening in our national discourse in the political environment. We know that kind of infiltrates down to the local level, but I think it's even more important today than ever before that we and you all adhere to the ideals and to the standards and not just your individual ideas. And lastly, when you all took your individual oath, you said, I do solemnly affirm that I will support the Constitution of the United States and the Constitution of the State of Illinois, and I will faithfully discharge the duties as council member. And I just want to encourage you all to really remain faithful to those ideals and not just the ideas that you all have. So hence, remain faithful to the standards. And remember, your duty is to those that you serve and not just your ideas. And it's not just your own ward, although the ward is who voted many of you all into power, into position, but the focus is on the fact that we are one city, right? And I just really want to underscore the importance of that and encourage you all to really remember that when things get difficult, because we are one city. And this council is very diverse, not just in terms of race, but also ethnicity, age, professional experience. And when we think of diversity, diversity itself can be a great challenge. But it's how you galvanize that diversity towards a common goal. That's the key. And I think of the Chicago Bulls back when they were winning championships, and Phil Jackson, and how he had a very diverse team, and that team nearly imploded because of that diversity, but how he galvanized them around a common purpose and a common mission. That was the key to their success. So as you all grapple with very difficult issues and challenges, I just want to encourage you to adhere to the standards, to the ideals, and remember the common goal that you all are all here to serve. And amongst that diversity, Mayor Biss, we appreciate your mathematical skills in terms of helping to deal with this budget that you all are going to be grappling with. So without further ado, everyone has the agenda, correct? Yes? Okay. So just for the sake of the public who may be viewing this at home, we're going to have someone from Elrod Friedman. Okay, good. So we have representatives from Elrod Friedman who are going to present. We'll take a break, and then the fun begins, right? There's Robert rules, the legislative process, the overview of rules for the city council, the committee structure, and a mock city council meeting before we break for lunch. And thereafter, we'll have the law department speak, we'll have closing comments, and then we are done for the day. So when you all are speaking, if anyone is, I'm going to keep everything moving. If you are going beyond the time, I'll give you a signal. If I put up 5 fingers, that means you have 5 minutes to go, 3 minutes, 2 minutes, 1 minute, and then it's time to cut it. Because I'm sure no one will argue for leaving early today, right? But no one wants to stay late. And in the words of Peter Braithwaite, buckle up. Now is when the work begins. So thank you all. So next we have the representative from Elrod Friedman.
Good morning, Mayor Biss, City Council members, Clerk Mendoza, City staff. We're thrilled to have been invited to be part of your City Council orientation. My name's Brooke Lenneman, and I'm here with my colleagues and the founding partners of our law firm, Peter Friedman and Steve Elrod. So thank you very much for having us. I'm going to turn it over to Steve to give a little introduction, and Peter will introduce the topics we're going to cover, and then we'll jump in because we have not too long of a block of time. So, Steve?
All right, we loaded up.
Mr. Mayor, I hope that doesn't detract from our total time. Good evening, good morning. I'm Steve Elrod, and yes, we are thrilled to be here. Elrod Friedman is a small boutique municipal law firm. We were formed at the beginning of the pandemic in March or April, in February or March of 2020. We were the land use and local government group of the law firm Holland and Knight. We created our small firm with the desire of operating with the overhead of a small firm, but with the sophistication and service level and knowledge bank of a big firm. Our attorneys have been advising local governments for nearly 40 years. We serve as corporation counsel and village attorney on a special or general counsel basis to more than 20 different local governments, several of your neighbors, primarily in northern Cook County and in Lake County. And we enjoyed for many years a very nice connection to the city of Evanston, as our late partner Jack Siegel was the corporation counsel here in Evanston for many, many years. I'm going to turn it to Peter Friedman to give you an overview of what we're going to talk about this morning. We have a loaded, pack-loaded agenda for you, and we're going to get started right away.
Good morning, everybody. Again, Peter Friedman. It's great to be here with you this morning. As Stephen Brooks said, we're going to cover a lot of procedural issues and kind of some important local government issues. But I wanted to say that we've done this since the election. We have done, a lot of our clients, almost all of them, have asked us to do this exact same thing. So we commend you for doing it. It's an important thing to do. We've done it for Des Plaines, Northbrook, Highland Park, Waukegan earlier this week. So again, we commend you because it is very important for this type of activity. We're going to cover today some general local governments issues, Freedom of Information Act, Open Meetings Act, and then some ethical issues regarding the prohibited political activities. Our emphasis today is, as you all know, you all are the policymakers. All of the things we're going to talk about today are procedural in nature so that we get the procedure right, so that your policy has the best chance to stick. And I'll turn it back over to Brooke.
Sorry, we're trying to get a clicker that works.
This clicker worked a few minutes ago.
Is it that white?
No.
Oh, there it goes. It's working now.
Oh, okay.
Oh, you
Sorry.
have them, yeah.
There you go.
All right, so those are the topics we're going to cover today. Sorry, the slide wasn't up earlier. Do you want to talk about it?
No.
No, I'm not clicking it, I think.
There we go.
Okay.
Thank
All right, yep.
All right. So as we indicated, this is going to be sort of Municipal Law 101. It is geared primarily to the newly elected officials among you, but for those of you who have been around for a while, it may seem familiar. It's always good to have a refresher, we believe, but chime in if you have questions. We're certainly are open to that. Actually, we're reserving time at the end for all your questions. So we're starting really at the very beginning. We're starting with federalism, and to try and determine the source of local government power. Everything flows from the United States Constitution. As you know, any power that's not granted in the Constitution is reserved to the states, and that's the whole essence of the 10th Amendment. You've heard a lot about the 10th Amendment in the past couple years. It is because the 10th Amendment is where all the states get their powers, but nowhere in the United States Constitution is there any mention of local governments. It's only the federal government and the states. And that's because it's all about the states. Local governments didn't really exist as a matter of a law under the United States Constitution. The states have the ability to determine what to do about local governments. And every state can determine whether and how many and how to operate local governments. And to what extent it even wants to allow or have local governments. In Illinois has done so big time. Illinois has created more local governments, or allowed for the creation of more local governments than any other state in the entire country. It has basically categorized them into these 5 different categories: counties, townships, special districts, school districts, and municipalities. We're going to concentrate on municipalities because Evanston is a municipality.
Steve, And by the way, we're going to interrupt each other, so this will just be the first of many. But wasn't at some point Evanston also a township?
Evanston actually was both. Evanston was one of the few the few locations in the entire state that had a coterminous city and township. Many of you know this, and again, this is trying to be helpful to your newly electeds, but also some refresher for those of you who have been around. And it's interesting because Evanston actually did its share to help reduce government in the state of Illinois by eliminating, by referendum, the township government, which was a coterminous government with Evanston. So now we have in Evanston just a city form of government. And I'm using the word city as opposed to village. And, throughout the state of Illinois, you have cities and villages. Does anyone know the difference between a city and a village? If you don't, that's great, because there is none. There really is no difference between the two as a matter of law. Yes, there's some minor there's some minor nuance about how they are incorporated in the first instance, but at the end of the day, they are synonymous as a matter of Illinois law. Rather, what really matters is the form of government. And can we switch? In Illinois, there are 4 types of governments for municipalities. There is, under Article 4 of the Illinois Municipal Code, the commission form of government. That's where there is a mayor and usually 5 commissioners. Each commissioner is the head of a department. A commissioner is the head of fire, and a commissioner is the head of police. A commissioner is the head of finance. And each one of those takes on the day-to-day operations of that department. There's a strong mayor form, which is Article 6. In a strong mayor form, the mayor is not only the head of the public body, but the mayor is the full-time administrator of the municipality, with all departments, all employees reporting to the mayor. Chicago operates under the strong mayor form. There is the Article 3.1 council mayor form of government. That's the default government. Most of the municipalities in Illinois and many of your surrounding suburbs operate under we call it the 3.1 form. It's sometimes known as president trustee, council mayor, but it's where the mayor is a part-time official. The mayor is the head of the public body, and the mayor has quasi-administrative responsibilities, not full administrative responsibilities. Those are usually delegated to an administrator or a manager. But the mayor appoints the department heads, the mayor appoints the police chief and the fire chief, etc. The 4th form of government is the managerial form. That's Article 5. Evanston is the managerial form of government, sometimes known as the council manager form of government. Evanston formed it by referendum back in 1952, and a managerial form really does separate the legislative power from the managerial power. Under the managerial form of government, the city council hires a manager, typically a full-time professional, educated manager that runs the day-to-day operations. The manager is the CAO, the Chief Administrative Officer of the city. The mayor is reduced to really a member of the city council. And the mayor is certainly the head of the public body. The mayor performs ceremonial functions, but it is the manager that runs the day-to-day operations. The manager is in charge of executing the policy that's set by the public body. The manager hires the staff, the department heads, the attorney, there may be differences and nuances within the city of Evanston, but generally it is the manager that hires all of the department heads. The other distinction between between governments in Illinois is whether or not a government has home rule authority. If we can switch to the next slide. Home rule did not exist until the 1970 Constitution. Before then, every local government in Illinois operated under what was called Dillon's Law. Dillon's Law or Dillon's Rule meant that there is no independent authority by a local government to do anything. If the local government wanted to do anything, exercise a right or impose a regulation, impose a tax, it had to go to Springfield and get state legislative authority. There had to be something in the Illinois Municipal Code in order for the local government to act. That wasn't a big problem for many small governments for years and years because they were more or less the same, but you had the city of Chicago, which was different than many other municipalities. For example, the city of Chicago was the only municipality that had tall buildings, and they needed elevator regulations, and they had to go to Springfield to get elevator regulations. That frustrated the city of Chicago and to a certain extent large cities like Evanston. And when the state was considering a new constitution or a comprehensive amendment to its constitution in 1970, and it was desired by many downstate representatives and elected office holders, the only way they could get it passed was to get the support of then Mayor Richard J. Daley. And Richard J. Daley said, the only way I'll support a comprehensive amendment to the Constitution is if there's a home rule provision in it. And that's how home rule was born. It became, and Illinois created one of the most liberal home rule provisions of any state in the country. It basically reversed the presumption of Dillon's Rule. It said that instead of going to the state for authority, there is a presumption that anything related to the government's municipal affairs is allowed unless the legislature prevents it, or in home rule parlance, preempts it. The home rule is found in Article 7, Section 6 of the United States Constitution. It was home rule units became, or municipalities became a home rule unit automatically when they achieved 25,000 in population. Evanston was 25,000, was above 25,000 in 1970, so you became home rule automatically in 1970. Others can become home rule by referendum. And if you are home rule, you can, by referendum, eliminate home rule authority, and one municipality has done that in the history of Illinois. As a home rule unit, as I indicated, you can exercise any power and perform any function, and that includes the ability to tax and incur debt. But there are specific prohibitions that are built into the Constitution concerning home rule authority. One is you can't incur long-term property tax debt. You cannot define a felony. You cannot create something that constitutes a felony. You can't punish by imprisonment for more than 6 months, and you can't impose an income tax. So if that was on your agenda, take it off. The city of New York may be able to, but not in Illinois. Even a home rule unit cannot impose an income tax. A home rule unit can alter its form of government and provide a different manner for electing its officers, but it could only do so by referendum. And then finally, there is the concept of preemption. That the state legislature can preempt even a very local, otherwise considered local regulation by home rule units by exercising the preemption right. It needs to do it by a supermajority vote, or could declare that the state has exclusive jurisdiction. And interestingly, Evanston was one of the trailblazers in defining what constitutes local authority in a debate between the state and local governments. There was a case back in 1981 called Evanston versus Create. It dealt with your original landlord-tenant ordinance, and realtors and landlords sued Evanston, saying that the adoption of your landlord-tenant ordinance did not constitute a proper exercise of home rule authority, and because the state had a landlord-tenant ordinance, the state automatically preempted Evanston. Evanston fought it. Actually, our partner Jack Siegel fought it on your behalf and prevailed, and it's now one of the foremost cases on home rule authority for allowing a liberal interpretation of home rule authority. Thus, Evanston validly exercised its home rule authority. So, it can apply to counties. There's a different method by which counties can become home rule. There is only one home rule county in the entire state, and that is Cook County.
Let me just ask, do we have a mechanism for Q&A?
We're going to reserve time at the end for Q&A.
Okay, great,
So,
thanks.
but all good. We're going to move on to our next topic, which is sunshine laws.
You can move to the next slide. Thank you. So the first sunshine law we're going to discuss, and an act that affects your day-to-day business as city council members, is the Open Meetings Act. The basic policy behind the Open Meetings Act is that all of the actions and deliberations of your government should be able to be seen by the public and observed. So the Open Meetings Act provides a set of regulations to basically make sure that public meetings can be observed by the public. So the first, actually you can stay on that last slide. Sorry. So the first, obviously Open Meetings Act is called the Open Meetings Act, so it only applies to meetings. And so we should first talk about what makes a meeting under the Open Meetings Act. So a meeting is defined as a gathering of a majority of a quorum for the purpose of discussing public business. So in Evanston's case, you have 10 city council members, so a quorum is 6, and a majority of a quorum is 4. So anytime you have 4 people gather together, 4 council members gather together to discuss public business, that's a meeting. Do you have a question, Mayor Biss? No? Okay, sorry. We often get asked, so what happens if 4 city council members are, going to a Cubs game? Is that okay? And the real, determination is, are you going to discuss public business? If you're there and you manage to not discuss public business for the entire game, then it's okay. But obviously that's a very perilous situation to be in. And if you do happen to discuss public business, that would be considered, and it's outside of a noticed meeting, then that would be considered a violation of the Open Meetings Act.
So the other thing to note here is this is a majority of the quorum of the public body. So if we're talking about the council, that's a majority of the quorum of the council. So that's 4. But if that doesn't include staff, so staff doesn't count for who can be in the meeting in order to trigger the Open Meetings Act. And it doesn't apply to members of your ZBA or others. So if 3 members of the council and 1 member of the ZBA are in a meeting or in the same place talking about public business, that's okay. It's not triggered because that ZBA member does not trigger the Open Meetings Act because they're not a part of this public body.
Be careful also if you have committees of the council. If there are committees of the council, and do you, that are smaller? Yes. So those each and of themselves are public bodies, and you do the calculation there. So it may be less than 4 or less than 3 that could gather if a majority of a quorum of the committee is getting together to discuss business of the committee. So be careful in the overall calculation.
If you can advance this slide, thank you. So discussing public business obviously is a main component of this. And when determining whether public business is being discussed, the Open Meetings Act contemplates this concept of contemporaneous communication. Contemporaneous communication obviously is, people in a room discussing something, a group text, WhatsApp, text, anytime that there's a discussion of public business sort of relatively in the same time frame amongst that majority of a quorum. Where this can get really sticky is in social media, because I think it's just a time when you don't think of it being a discussion or a communication. But, take the example of there being a Facebook page for, community project, and a council member posts a post on that Facebook page, and then another council member responds, make comments on that post. Now and if this is all happening in a relatively confined time frame, you now have city council members discussing public business, a city, community project, together, and potentially if you have a majority of a quorum, you have an Open Meetings Act issue. So it's a time that you want to, be very careful about. You don't know else is listening to these comments online and who may jump in and participate. You can't control that. So it's just a very, a place to be very careful.
We get asked this question all the time, like,
Is that on?
I think it is.
Right.
Where's the line when you're talking about contemporaneous? Is it like right away? What's right away? Is it the next day? The answer is there is no, the AG and the courts have not provided a rule. So we err on the side of, it's a one-way communication that ends there, does not trigger. But any kind of, when you start replying to that, depending on when no matter really when it is, yes, if it's a year later, that's probably not contemporaneous, but, there's no real direct line, so we err on the side of don't engage in electronic communications where there's more of a majority of a quorum.
And another example of that that's just really common is, say, the city manager sends out an email to the entire city council, maybe an update to the agenda or something like that. That's fine. That's that one-way communication. City council, the city manager's not a member of the council, and it's like sending out a letter. But when someone hits reply all and says, I thought we were going to talk about that later, or I didn't know it was going to be on the agenda, and someone else says, well, we talked about it. All of a sudden now you've got, theoretically the entire city council discussing something over email outside of a meeting. So another just rule of thumb that we always advise our clients is just do not hit reply all, because that's just a place where you can get into some dangerous territory.
The other advice we give is, because sometimes we make mistakes about replying to all, is if there's a communication to the entire council, or you're communicating to more than four or more, BCC everybody and email yourself. So there's no way then for anybody, even if they hit reply to all, it's only going to go to the sender, and then you protect yourself against
Just
that.
to emphasize this, because it is so important, and it's bringing confusion, and there's actually possible litigation in another community on this subject. One council member or a staff member sending an email blast to the entire council is not a problem. It is a one-way. It is the two-way that makes it an open meeting. That's what you need to remember. The reply to all.
All right, so the Open Meetings Act, once you've determined that you've got a meeting, there's a set of other requirements to make sure that that meeting is open. So one of them is that all meetings need to be properly noticed. There's different types of meetings. There's regular meetings, special meetings, and emergency meetings, and all of those have slightly different notice requirements. I won't go through them, they're on the board, but just be aware that even an emergency meeting does need to have notice given, just to the extent practicable. Obviously, in an emergency, there's not always a lot of time to do that, but whatever you can do, you are required to do. And meetings are required to be held at times and places which are convenient and open to the public. So you can't hold a 2 a.m. meeting or, a meeting 100 miles away. And the next requirement that the Open Meetings Act requires of meetings is that there must be an agenda and there must be minutes of the meeting. So the agenda, you've all seen them. One question we get frequently about an agenda is, does everything you discuss during the city council meeting have to be on that agenda? So can you only discuss the items that are on that agenda? And the answer is no. So the Open Meetings Act does contemplate that you can discuss and consider topics or items that either come up during public comment, or someone just wants to raise during another opportunity in the meeting. But the Open Meetings Act does prohibit taking final action. So you cannot vote on an item that has not been put on the agenda first.
So just a couple things. One on the minutes. Oh, thank you. On the minutes, everybody's got different forms of minutes. We get asked this all the time about how detailed the minutes have to be, or how non-detailed the minutes should be. Legally, the only requirement is that the minutes say what happened at the meeting, and not necessarily everything that was said at the meeting. So it has to say when the meeting convened, who was present, what votes were taken, who made the motions, who seconded, what the votes were, and any other procedural issues that are handled at the meeting, and when the meeting adjourned. That's the bottom line legal requirement for meeting. Now, a lot of times there's more general description about what a motion is, but we advise against even attempting to go very far beyond that and try to say, try to provide summary of comments from each member of the council or members of the public, because inevitably there's no way to do that unless you're literally taking a verbatim transcript of it, and we don't advise that. It's certainly not required. So minutes become important. It doesn't have to be an issue, but when you get into a lot of detail, oftentimes it becomes one.
Well, and one of the issues that can happen is, you can't, if you have a 3-hour meeting with a lot of public comment and the minute taker includes some people's comments and not others, someone's saying, well, why was their comment included in the summary and not mine? Or by including these comments and not others, it kind of puts an unnatural emphasis that wasn't actually at the meeting on a particular opinion or topic. So the danger is that the summary that you're trying to make is actually not as accurate if it had just been like really pared down and just kind of hit the general summary. So the next requirement of the Open Meetings Act is that there should be public comment.
That photograph, by the way, is not taken in Evanston. Just no comment, but.
So the Open Meetings Act requires that any person shall be permitted an opportunity to address the public officials under the rules established by the public body. So up front, I think it's useful to just make a distinction between a public meeting where that requirement applies and a public hearing.
Let me just chime in on that. That's a very important distinction. When the city council meets, most of the time you are meeting in a public meeting. There may be occasions, certain budgetary issues and other nuanced areas of Illinois law where you may need to have a public hearing. Those are far and few between. For the most part, you are meeting as a public meeting. There is a difference between a public meeting and a public hearing. A public meeting is for the public to observe your meeting, but it is your meeting. It does not give the right to the public to participate in your meeting. It gives the right to the public to observe your meeting in a gallery. If you were in Congress, they would be elevated in a gallery. A public hearing, on the other hand, gives the public the right to actually participate in the meeting, in the hearing. They have the right to confront witnesses. They have the right to make statements. They have the right to responses. That is not the case in a public meeting, and that's important. Now, the Open Meetings Act, as Brooke indicated, gives the public an opportunity to comment, and you have on your agenda public comment time. That is for the public to make comments to you. That's their First Amendment right to address the government. But they don't have a First Amendment right to have an engagement in a conversation with government. For political reasons, you may want to do that in your wards or separately with the public, but they don't have a right to a discourse at a public meeting. They have a right to make a comment, and I think your rules are very clear that they have that there is no obligation on the part of the City Council to respond immediately or at all. That is a legal answer. What you do politically is, of course, up to you, but I want to make sure you understand that distinction.
Right. And engaging in the back and forth during public comment can often, it drags the meeting out. It can kind of start to fray the general structure of the meeting, so it can get a little out of hand. And often the best reason to respond later is just because you have a chance to discuss with staff, look into it. You're not just put on the spot and giving an answer right then. But obviously we realize that's really hard to do because often the public brings up really good questions that you feel the need to respond to in the moment. So it can be difficult.
Remote.
Oh, and I'm going to turn it over to Peter to discuss remote participation. Oh, sorry, Steve.
Okay.
We're interchanging.
We're all experts on this. This is an interesting one, remote participation, because the whole world changed a year ago. But let's talk about first pre-pandemic remote participation, because we could be going back to that world shortly. Pre-pandemic, Illinois had very strict rules, probably stricter than any other state, on allowing remote participation. It was very difficult for council members to participate remotely. They had to fall into one of three very limited categories. They had to be seriously ill, they had to be away on a legitimate bona fide emergency, or they had to be away for their own work-related matters. If somebody had a second house in Wisconsin or Florida and they wanted to participate on a regular basis, they could not do so. That is, or they were on a family vacation, not legitimate for participating remotely. Evanston actually added a fourth requirement that you could only, even if you did fall into one of these three categories, you can only exercise that right once a year. That's the pre-pandemic world, and that's where Illinois was. Once the pandemic hit, and Illinois sort of came in pretty late in the game compared to other states, if you switch to the next slide, Illinois had certain rules that we were currently operating under, frankly, that allow for remote meetings, but there have to be two prerequisites. One, the governor has to have declared an emergency, which he has, and two, the head of the public body, in this case the mayor or any of the other bodies, the head of that public body, has to make a finding that an in-person meeting is not practical or prudent. And then you follow the procedures that you're intimately familiar with, that you've been doing for the last year. You have to have a roll call vote on everything, and all the members of the public have to be able to be able to be heard and observed.
I was going to say that.
Go ahead.
The one thing we're getting asked now a lot is, as we're in this bridge phase, moving to phase 5, the simple fact that we may get to phase 5, as long as the governor's emergency declaration still exists, the remote rules for the pandemic still exist.
Provided that the mayor has
correct.
also made the concurrent second finding that is required. But once we're in phase 5, it is very likely, in fact, it is likely any hour now, that the governor may change things and eliminate his own rule. He's been known to do that, particularly on Fridays at 4:30. And it could be that he'll eliminate that first finding. And if he does, even if your mayor desires to have it, you're unable to. Both the governor and the mayor have to issue have to make the findings. And then we'd be back to the old rules. Now, there has been, and Commissioner Sufferman may know this, that there has been legislation pending in Springfield to change the Open Meetings Act, to expand the ability to have remote meetings, particularly since it was done so successfully under COVID. But that has not, it certainly is gone nowhere in this session, and we'll have to wait to see what happens next year. Next slide. And next one.
Okay, so now perhaps the most litigated or challenged or controversial aspect of the Open Meetings Act, which is closed meetings. We like to say, just so you know how courts and the Attorney General interpret the requirements around closed meetings, that it's the Illinois Open Meetings Act, not the Illinois Closed Meetings Act. So whenever we're going into closed session, any interpretation issues about whether we did the procedure right, whether we went in for the right reason, whether we kept it under the right discussion, if it's ever challenged or reviewed, the presumption is it's a very strict construction against the closed meeting. So we have to be very careful, and we're vigilant about it. So the three things to remember: you have to go into the closed meeting correctly, and that means a correct vote for a correct reason. And then once we're in closed session, we have to stay in our lane. We have to only talk about why we went into closed session. So the first thing, the motion. There needs to be, in an open session, there needs to be a motion to go into closed session. We can't go into a closed session unless we're already in a meeting. Can't be somewhere else without not being in a meeting, an open meeting, and then try to have a private meeting. Not allowed. So there has to be, in an open session, there has to be a motion. It has to be seconded. That motion has to specifically identify the statutory reason for going into closed session. And those reasons are laid out. There's
Peter, wait, does the agenda have to say that there's going to be a closed session?
So the answer is no. Traditionally, many municipalities put and they're all over the board on this. Some put closed session and that's it. Some put closed session and then specifically identify for that meeting the reason they're going into closed session. But that is not, none of that is legally required. And the reason is, you could be in an open meeting and somebody could stand up, an applicant, a member of the public, and say, I'm going to sue the city. You now have a reason to go into closed session. If you want to go into closed session right then, if you do the right procedures, you can, regardless of whether or not you anticipated it or whether it was on the agenda. So that motion has to, again, specifically state why, and then it has to be approved by a roll call vote. It has to be a roll call vote.
Even outside of the pandemic, it has to be a roll call.
Correct. So now we do the motion, we do the second, we're into closed session. Who gets to come into closed session? That is up to the council. The only people that really can't be excluded from a closed session are members of the council, except in very, very extraordinary circumstances. But ordinarily there's staff, there's an attorney, and sometimes there's a private party that you may be negotiating with on a project. That's okay. It is up to you, the council, who gets to attend closed session.
There is an argument in Illinois that the city clerk also has the right to be in every closed session meeting.
Right, and there's a statutory procedure for that as well. Yep. So now when we're in closed session, we have to stick to a discussion only about the reason we went into closed session. So if we go into closed session to talk about pending litigation, that we cannot talk about collective bargaining, even though collective bargaining is a proper topic for closed session, because that wasn't part of the motion. The public has the right to know why we're going into closed session, and we're not allowed to veer from that once we're in closed session unless we've alerted the public beforehand. And we're very vigilant about this. It is very easy. I mean, the reason for the closed session is to allow you to have frank, honest, strategic conversations and really get to, some difficult topics sometimes. But that level of frankness and openness sometimes just naturally can veer outside of the specific reason for the closed session. And there needs to be vigilance there, because the consequences of going outside the lane is, if challenged, one, the first thing that happens is those verbatim recordings go to the AG or go to the court. So they get to hear everything. So there's nothing, you can't hide anything. It's whatever's on the tape is on the tape. And if it is found that it was improper once we got into closed session, the recording becomes public. So the consequences are severe. Practically, and also, as a PR matter, having an improper closed session is just not a good place to be.
Peter, talk about one of the most common abuses or reasons that is typically abused for going into closed session, the probable litigation.
And abuse sounds like it was deliberate, but oftentimes it's not. It's just a difficult sense. So one of the reasons to go into closed session, of course, is talking about pending litigation. That's easy. You have a lawsuit that either a plaintiff or a defendant in the city, easy to go into closed session. The other one is probable or imminent litigation affecting the municipality. So it's probable or imminent. Now that has been that.
Wait, Peter, before you get one distinction: pending litigation affecting the municipality. That doesn't necessarily mean that Evanston has to be sued or Evanston is the plaintiff. If there's a piece of litigation against the village of Skokie that could impact Evanston, it's possible for you to go into closed session to discuss that pending litigation, because you will be able to make a finding that it affects the city of Evanston.
Correct. So probable or imminent, it's got to be those words. It's got to be probable, and in our view, that means more than 50% likelihood. And it's got to, or imminent. It's somebody stands up and said, I'm going to file tomorrow, or, imminent. What it is not is possible litigation or could be litigation. That is crossing the line. And there was a recent case, a recent Attorney General decision, where a municipality was negotiating an agreement with a private party, and it was becoming contentious, the negotiation, and the private party stood up at a public meeting and said, "That's it, I'm going to hire a lawyer." And the council interpreted that in a threatening manner, thought that that meant there was going to be litigation, went into closed session under probable and imminent, and that party challenged the decision to go into closed session and have the discussion. And the Attorney General found against the city, saying just because somebody hires a lawyer doesn't mean that litigation is probable or imminent. You need the magic words. You've got to look. And the statute actually says that, and this is the only element of the statute that this has this requirement, that there has to be a specific finding on the factual basis of how you concluded that litigation was probable or imminent. So this one's a sticky one. And you got to be vigilant about why. I just want to mention a couple of the other tricky ones. Personnel matters. Again, it's not a general discussion of budget for all city employees. It's specific employees. You have to be discussing all sorts of things regarding specific employees, performance, achievements, whatever, but it's got to be specific employees. And security procedures. I mentioned this one because we never really used this one up until about a year and a half ago. And then with COVID and civil unrest matters, we've actually used this one a lot. And it's valuable and it's legitimate. So it has come up a lot over the last few years, or the last 15 months. What's that? Yeah. So what happens when when there's a problem? The consequences, as I said, everything can become public, but the violation is, civil suits, attorney's fees, and crimes. There's actually a jail term for violation. I don't think it's ever been utilized, but it's in the statute. And as I said, everything gets reviewed either by the court or the AG. So once there's a challenge, the whole record goes up. And so any kind of confidential conversations become not so confidential anymore.
So let's move on to the Freedom of Information Act, the other sunshine.
And I think Alderman Fleming has participated in our Human Services Committee. So we made a change right around the time that our police adopted the body cameras, and that we made a provision that we could go into executive session as a Human Services Committee to view that body camera footage. And typically, it would come up if a resident was present at Human Service, made a comment about the body video, and then we'd probably see it at the following committee meeting. I'm assuming that that's within the laws that you just presented a moment ago.
So I would answer that, unfortunately not definitively, because I think I would need more facts, but
Okay.
that commission, the body, has to be determined to be a public body. 'Cause
Human
only
Services
public bodies
Committee.
can go
Okay,
into closed
check
session.
that
And
box.
then we'd have to find an exception as to specifically why. The mere fact of the body cam, that's not listed as an exception under
Right.
FOIA. We'd have to fit it into some exception, and it would depend on the facts.
Okay, personnel.
Yeah, and keep in mind that the Freedom of Information, the Open Meetings Act is a state law that preempts home rule. So home rule communities cannot create their own exceptions to the Open Meetings Act. You have to fall into one of the categories that it's specifically set forth in the state statute. And it may well be, but again, we'd have to look at the specific facts to
So
give
is
you
that
an
one of
answer.
the things we have to follow up and look at? Because I think we may have done it, maybe once or twice, if even that much in the past?
It's likely pending or probable litigation, but I wouldn't even know that.
Okay,
Or it could be specific personnel as well.
okay. Talk about it later. Thank you.
Are we on pace to still have time for questions at the end? All right. Do you want to go now, or do you want to hold?
Oh, I think we're just trying to save time, so
By the way, did you all receive our 50-page report? Everything we've talked about, plus more, and all the case citations are in here.
I just think this happens to be important for this body, the biannual review of closed
Yes,
session.
absolutely.
Yep.
We're happy to cover it.
So, thank you. The minutes of just like open session minutes of closed session, there has to be minutes of closed session. You know that all closed sessions are now recorded. That was a new statutory requirement of about a decade ago. Those recordings have to be maintained for 18 months at a minimum. They can be destroyed after that 18-month period. There's no requirement for the destruction, but they're authorized at the City Council's direction to be destroyed, but only, again, after 18 months and after the minutes of that closed session have been approved by the council. So that nothing can get destroyed from the recordings unless there's a record in writing with those minutes of that meeting. You're right, there's the biannual review of the minutes, and that's just to review. And the reason for the review is you have the ability with regard to your written minutes. I mean, there's the approval of the minutes, and then there's whether they should retain their confidentiality, whether they should continue to be not subject to FOIA, because closed session minutes are not subject to FOIA. The council the council is supposed to review those every 6 months and determine whether there's a need for confidentiality. That is largely and broadly within the realm and the authority of the City Council. We know of there has been no case where a court or the AG has overturned the decision of a council to maintain the confidentiality of those minutes. Very broad discretion. If the minutes are determined, if the council determines these minutes don't require confidentiality, then they are deemed to be released. Release does not mean that they're put on, it just means that if somebody FOIAs those minutes, then they're subject to FOIA, as opposed to not being subject to FOIA. But it doesn't mean that they have to be immediately sent out to the world.
Does the destruction of the verbatim record happen only after they're released?
No, just after they've been approved. Right. So speaking of FOIA, we're running a little short on time, so we want to make sure there's time for questions. So we'll try and move through the rest of the presentation pretty quickly. But so FOIA is sort of a counterpart to the Open Meetings Act. It ensures that the documents and records of the government the presumption is that they're open to inspection and copying by the public. That said, FOIA doesn't require all records or all parts of records to be, you can advance this slide, Nick. It doesn't require every part of a record to be disclosed. It provides, I don't know, I think there's 70, possibly more exemptions. Most of those exemptions are voluntary. There's no necessarily penalty for not taking the exemption, although there's many good reasons to take them. We're not going to go through all of them or even the ones that are all here, but the most commonly used ones are for private information. We kind of refer to those as the identity theft type information, your social security number, home address, birth dates, that kind of information. And then the next, I think, most frequently used exemption is for personal information, and that's for information that's highly personal information that is just unreasonable to assume the public should know. And basically, most of these exemptions are there as like a policy balancing, where they're saying that the interest of the party to keep this information private outweighs the public's interest in knowing it. So that's kind of for the personal information, that's kind of the balancing test you may use to redact information.
Brooke, I want to pause on one of them, which is preliminary drafts. Frequently, a document will be marked draft in order to protect it from being released under FOIA. That's a very common practice, legitimate practice, but be careful. There's an exception to that. If the mayor, not a council member, but if the mayor refers to that draft in a public meeting, you lose the exemption. So, Mayor, be careful when you have a draft in front of you, and I've seen it happen. A council member can refer to it, but the head of the public body cannot.
So there's the voluntary exemptions, but FOIA also contemplates and makes provision for the fact that there are many statutes, state statutes that may prohibit the disclosure of information or even the disclosure of an entire record. So examples of that are HIPAA, the Juvenile Court Act, the Abused and Neglected Child Reporting Act. These are all acts that prohibit information from being given to anyone other than an authorized recipient. And so just because someone submits a FOIA request for that information, you still have to go back and think what information is in this report. Some of it is not voluntary. It's actually required, and in some cases it's a misdemeanor to release those records. So it's an important evaluation. So one topic that we just wanted to make sure we highlighted today that affects public officials is what is a record and when is that record in the possession of the public body? Because FOIA really only applies to public records which are in the possession or have been prepared for the public body. So there's been an evolving body of case law that has really broadened the idea of what kind of records the public can get. And so I'll let Peter discuss that.
So as Brooke said, the key issue here, this is emails and texts and when they're subject to FOIA. So the key issue here is, and FOIA applies to the public body. So who is the public body? Obviously, when there's emails or texts that are on the city's server, those are in possession of the city, the public body, and those are all subject to FOIA, subject to the exceptions, but they're all public records under FOIA. It doesn't matter how they got there. Doesn't matter if they came from a personal device on a personal email account, a text. Doesn't matter if they're in possession of the city server or the city, if they're hard copy in this building, they are potentially FOIA. The tricky issues, and this is the stuff that has evolved over the last 10 years because the statute was written before there were emails or texts. The tricky issue is, what about texts and emails on your personal devices or on your personal accounts that the city is not in possession of at all? And the first indication of where the courts were happened in the city of Champaign. Council members were at the dais, and two of them were texting each other during the meeting. There was a reporter in the front row, saw this going on, FOIA'd and said, I want those texts. The city said, we don't have those. Those were on personal devices, personal accounts that are not in possession. Court said, disagreed. And the reason the court said it is, look, council members, other than the mayor, are outside of a meeting, really have no independent authority. The council members' authority is when they're sitting as a body voting. That's the essence of their power. And so when they're at a meeting, texting like that, that's in the possession of the body because the body is meeting. So those private texts, assuming they're about public business, were FOIAble. Now,
even though those texts were not on the city server, they're on Verizon or T-Mobile, and it became a tremendous burden for the city to have to get those, but they did have to go get those texts from Verizon or T-Mobile because they were technically in the possession of the city when the council member was at the dais.
The next expansion of this was, what about employees? And this goes to the Laquan McDonald situation in Chicago, where after that and during the investigation, the police officers on their personal devices, sometimes the personal accounts, were texting or emailing each other about the investigation, about public business, but those were not on the city's server. The media FOIA'd those, and the court said that those employees, outside of any meeting, of course, but those employees, particularly police officers, have the ability to act on behalf of the public body outside of a meeting. They're always acting on behalf of the public body. So regardless of where those texts or emails originated, they were public documents, public records available to be FOIA'd. So the next expansion was, and this is just in 2020, what about the mayor? Or what about department heads, key governmental officials? And this was the BGA case that BGA filed against the city of Chicago and former Mayor Rahm Emanuel around when during the school strike. And there was a lot of emails. We all remember Mayor Emanuel liked to use his email, and they were on his email account and private device. And the court said there that the mayor has independent authority to act on behalf of the public body outside of the context of a public meeting. So the mayor always is the public body. So any emails or texts from the mayor and also from those department heads which are just like other employees. They also had, at least in Chicago, had the authority to bind the city and act on behalf of the public body. So also there, regardless of whether the city had possession of any of that, those were also public records subject to being FOIA'd. So knock all that down, if you're doing the math, the only public official outside of a meeting whose emails or text potentially is not subject to FOIA are individual members of the council, other than the mayor. Because outside the council, they don't really have authority. Now, we would say that that's just where the law is now. That case really hasn't happened yet, so I wouldn't want to rely on it comfortably.
If you talk to the PAC, the political, the public access counselor of the Attorney General's office, they're of the opinion that every text at any time is all subject to FOIA. We disagree, but that's today, as Peter indicated, and this law is definitely evolving. So I would be very careful. Certainly be vigilant when you're sitting on the dais.
So we had initially planned to give a brief overview of prohibited political activities, but I think we're running out of time, and I want to make sure that we have time to for questions.
And all of this is covered
so
beginning on page 15.
Right. So we have the prohibited political activities, gift ban, conflict of interest are all in the memo that we handed out, and those are also obviously all requirements that are in your code. So I think we'll just skip it if that's your preference, and we can take questions.
Make sure we have time for questions.
Right, to
You
make
just
sure, because
cover it in a
we're
minute.
running up.
Just take a minute, 60
Well,
seconds.
let's just first do a census and see how many questions
Yeah.
there are. So if you have a question, if you could either raise your hand or flip on your light, just so I have a sense of how much we're talking about. Is that a hand, Alderman Councilman? Well, I'm just counting questions. So I think we're going to have I think 5 questions, and so can you do like?
Yeah,
would
we
it be
can
helpful
do-
for Councilman Braith to do 30 seconds?
Absolutely,
or
absolutely.
Literally 60
Turn
seconds
back
or less?
a couple
Okay.
slides.
Sure. So the prohibited political activities, the State Officials and Employees Ethics Act and Section 110.4 of your city code prohibit political activities basically during compensated time. So
What's that?
Right. And so for elected officials, that can be hard to determine because, you know, you're not a city employee who come here during work hours. So really, functionally, that means when you're doing the work of the public body, sitting on the dais.
Or in a committee meeting.
Or in a committee meeting, or in a, work group meeting, in any of your official duties. So obviously during that time, you cannot engage in political activity. So that includes, saying, vote for me at the next election, like from the dais. You can't do that.
Wearing a campaign button, wearing a hat,
Fundraising.
Passing out flyers, right before the meeting starts.
nominating petitions. We've
but-
seen it all.
So there's that requirement, and then there's also a requirement that you can't use city resources for political activities, and that doesn't have any limitation about compensated time. That's any time. So you can't use your city email for campaign purposes. You can't use the photocopier to make flyers. You can't use, if you have a city-issued laptop, you shouldn't be using it for campaign purposes, that kind of thing. So that's a very brief overview.
Why don't we go to the questions, and if we have time after the questions, we can follow up on this.
Great. And in fact, what I'm going to do is I'm going to just call on everyone to enumerate their questions first so we can then figure out how to allocate the time to the different questions once we know what we have. So first, Councilmember Fleming. Just name your questions. Yeah, they'll ask it then. Could you turn on your microphone, Councilmember?
So, sorry, for the closed meetings, for the executive session slide, there was a list of permitted topics. Do those topics have to be discussed in closed session? Or are they just permitted to be discussed?
That's actually a great question.
I thought so too, thank you.
It's a great question that applies to both FOIA and Open Meetings Act.
Did you want to
These-
wait?
Do you want to do
Oh,
them, Mayor, or
I'm
do-
sorry, Mayor. Did you want to have us give the answer or just get the question?
All right, let's get them all out. If you're, let's stick with our plan. So next, Councilmember Nusma.
I have several questions I can address later to the city manager, Storley, internal procedures, but one for our team here. One question for our team here is, can you clarify whether or not the city clerk is allowed to attend closed sessions?
And I have two questions. The first is about the forms of government. I have had a heck of a hard time assembling what I would love to see is a spreadsheet of all Illinois municipalities and then a second column that explains what article they're organized under. Certainly, Councilmember Suffredin seems confident about the Cicero form of government, but there are many other municipalities in Evanston, and I've just had a really hard time accessing that. So I'm curious as to whether that exists in a single coherent place, as opposed to having to look on many municipal websites, and then even there get sort of not super clear outcomes. And my second question is requesting a clarification of the definition of final action for purposes of agendas for open meetings.
Can you guys throw some hard ones?
Were there any others, or is that everybody?
That's it, unless I missed anybody.
All right, real quickly, let's take Councilmember Fleming's great question. Both sunshine laws, freedom of information and open meetings, give you exemptions. None of them have to be exercised. There's a possible exception for personal information that may fall under some other protected statute, but those are only exemptions that are enabling you to use. You are not required to use any of them.
So the answer to your question is you can discuss probable litigation in open session if you wanted to. There's no reason why you can't do it.
And you could release a document if you want to.
On the city clerk question, yes. I mean, there is a statute that authorizes and directs that the city clerk be allowed to attend closed session.
It's a recent amendment within the last 10 years. The Clerks Association got that added to the state statutes.
That's been our
But
past practice.
home rule units may adopt, that doesn't preempt home rule units. And certain home rule units have adopted a local ordinance that gives the mayor the ability to determine who's in open or closed.
Regarding the spreadsheet of types of government, I have never seen that, and
tell you
we've
what.
tried to find something like that before.
Just in preparing for this week and giving these presentations to all of our clients, I went just to see which the Illinois Home Rule Organization and other entities would list as Article 5 managerial form of governments. And I saw listed on there Glencoe, which we represent, and I know is not, and other municipalities that just because they have a manager, somehow they got listed as the Article 5 managerial form of government. There is, regrettably, unfortunately, maybe it's something our firm could take on, but you will not find such an organized list.
The closest document I've seen to doing that is about 5 years ago during the previous administration and the reorganization of local government entities, the consolidation report, the committee. And I think that did a big dive on the different types of municipalities. I just don't remember whether it got into the
It got into home rule versus non-home rule, and that is a very good list.
Right.
That's an accurate list, which is or is not.
And then on, and we can all pipe in on this one, because this one, on what is final action, I mean, final action is something that binds the public body, particularly with regard to a third party. So procedural issues are, whether to recess or whether to, whether to recess, whether to adjourn, those are procedural issues that are not final action that have to be on the agenda. But any kind of, again, final action with regard to an applicant, with regard to a contract, with regard to an employee, with regard to something that binds the city, that's the kind of thing that has to be on the agenda.
Rice versus Board of Trustees of Adams County, 2002 case. That is the case on point that created this final action concept. So our memo does a deep dive into it, and in the interest of time, I could refer you to it. But I think Peter's general summary is a good one.
Like sort of substantive decisions.
It's
right. I mean that you can't. Right. A decision on substance, I think, is shorthand. Any other questions?
Did we hit all the questions? Can you go all the way to the very end?
sorry, I just have one quick question regarding the exemption that enables us to use closed sessions. So you said that, in other words, we could in fact discuss litigation, probable or imminent litigation publicly. And that means you could also release records, correct, of probable.
Right, FOIA is voluntary as well.
So that could also be released.
There's no other statute that prohibits it. But, of course, there's always strategic or,
Sure, but I mean in terms of
policy
legally,
reasons.
it could also be released, the records.
Correct. And that's why, to go into closed session, you have to vote to go into closed session. So if the vote passes, you go into closed session. But, in theory, the vote could fail and you still want to discuss it and then.
But we do exercise caution, and you want to make sure you talk to your FOIA officer if something has been determined to be, if the city has exercised its right to use an exemption, an individual council member, I would argue, does not have an independent right to then release a record. Please take that listen very carefully to to our advice to talk to your individual FOIA officer.
Councilmember Reed?
I hear you that an individual member does not have that right. So do you know of any municipalities that have, ultimately the public body, the council has the right, or the individual public body for the committee has the right to release a record or not release a record? Do you know of any, and we know that we have the option to go to the PAC, the public access counselor, or file a suit. Do you know of any municipalities that have an internal mechanism where the public body itself decides, if someone has a complaint or thinks the FOIA officer withheld something improperly, where the public body overrules that?
I do not.
No.
Okay, thank you.
Okay, our last slide, November 5th, 2021, we're going to have a substantive gathering of all of our local governments, and we'd like to invite the city of Evanston to attend. Save the date. We'll get a deeper dive into municipal law 101 things, more deeper into comprehensive planning, zoning, and other issues.
Thank you all very much.
Thank you so much. Very helpful presentation.
All right, thank you all. That is critical information. So if you want to keep your jobs, listen to L. Rod Friedman. So we're going to take a break for 20 minutes. See you all at 10:30, and then we will resume with the Robert Rules and the legislative procedures. See you then.
Good morning, and congratulations on your election to the various offices. I'm Joan Bunley. I'm that person. I moved from his ward to her ward 7 months ago, and I was contacted recently by the city to conduct this workshop for you, and I was pleased to do it. It was 3 years ago. You and I had a workshop supposed to be from 5:30 to 8 in this room. He was doing the city council rules, and I was doing parliamentary procedure, and we got kicked out at 10 o'clock. Okay, so you know that people did learn something. Okay, the introduction is somebody clicking for me? Yeah. Usually when people hear about parliamentary procedure, it's, oh God, that means we got to be polite and all that stuff. And I say, parliamentary procedure is a way of conducting business that everybody is on the same page. And, since Robert's Rules of Order is your parliamentary authority, and maybe none of you have seen it, this is it. This is the 12th edition, which came out. As a 30-year practicing parliamentarian, I'm responsible for knowing everything in here. Now, in your position, all you need is this, and you can get it on Amazon or Barnes & Noble. It's the 3rd edition, which is in sync with the 12th edition of Roberts. 144 pages, and everything you need to know about any meeting is in this book. So I think it's under $10. So this is for you. The other one is for me. Okay, one of the questions I'm asked frequently, what's a parliamentarian? Okay, what's parliamentary procedure? And even further than that is, what's Robert's Rules of Order? That's a way of conducting business. General Henry Roberts started this in like the 1700s when he was an Army engineer and so forth, and came home and decided meetings needed some rules to go by. But to make it short, I've developed over a number of years something that people can understand, which is What does a parliamentarian do? And instead of going into everything I've said so far, I just say, parliamentarians teach organizations to play nice. Didn't your mother teach you that when you went out to the first sandbox? That's what we're talking about, being polite, following the rules, everybody's on the same page, and so forth. So that's what we're starting with. Now, that second slide that said how to adjourn before midnight, that's how I have attracted people to come to these workshops, because their main concern is meetings go on too long, we don't finish the agenda, people talk too long, some people hog the floor. And I'm saying I can teach you how to adjourn before midnight. I know you guys over the years, I've been here a while, you don't adjourn often before midnight. But anyway, that is the opening. How I got into this is my second career. I am a retired registered nurse administrator. I was director of the Illinois Nurses Association. That's how I got into parliamentary procedure, because I had to plan the meetings, convention, orient the board, etc. So that answers all the questions about me. Okay, so what are the objectives? I think knowing the rules, why you do things, and protecting people's rights is important. So what we have here are some objectives: discussing the principles and rules, listing the steps in handling a motion, defining a main subsidiary and a privilege and restorative motion. And believe it or not, you'll be familiar with all of this at the end of this session. Next. We're going to list the rules governing debate, identify essential points to successfully preside over a meeting. Now, this doesn't only apply to this. You're kind of a legislative body, but it could be a garden club, a church. I have clients from, homeless organizations to religious organizations and professional organizations. But the rules governing debate are the same. We'll go over those, and identifying essential points to successfully preside over a meeting, should you have to. And number one, is, which I'm going to cover most of this morning, are utilizing the ranking motions. And I'll hand you a chart when I'm ready for that. So feel free to ask any questions at any point, because each subject can stand for itself. All right, what are the principles of parliamentary procedure? Order. There must be an orderly process. For example, you have an agenda. I've read your rules over 3 times or so in the last month, just looking at things, and they're very well written, and they conform with your parliamentary procedure, which is Roberts. One thing I want to stress is, and I was asked this by the person who contacted me, says some of our rules conflict with the parliamentary with Roberts. I said, no, they don't. As long as you're not breaking a law, your rules say that Roberts Rules of Order, it's newly revised, is the correct title, shall govern meetings except where they are inconsistent with our own rules and procedures. Any rule that you have supersedes the parliamentary authority. Is that clear? So you don't have to follow Roberts. Roberts comes if your rules are silent. Okay? So there's an orderly process, which I would say your own agenda is the orderly process. It says how every meeting should go. Equality, all members have equal rights. You can't recognize one person and deny somebody else, or call on somebody 5 times and somebody else 2. And then there's justice for all, what kind of covers everything. Okay, next. Decisions of the assembly or council supersede those of individuals. Not one of you can say, well, I want it this way. You make decisions as a group, not individual. I have worked for some organizations where the president or the chairman thought that they had a little more authority than anybody else. And I kind of nicely reminded them that the symbol, where is it here? I had my gavel. But anyway, the symbol of the chair is the gavel, not the crown, okay? Just remember that. Transact business legally, a quorum must be present. And rereading your rules, your quorum is 6 members. You have 9 council members. Chair votes in case of a tie. And I'm going to mention this now because I sent this as a correction that should be made to bring it to your attention. Your rules state, I think it's around 21 or 22, about actions can be approved by a majority of the quorum. If your quorum is 6, majority of the quorum is 4. There are 9 council members. A majority of 4 is not a majority, it's 5. So you want a majority of the council members, so I wrote that in the suggestion that I sent in. Is that clear to everyone? Majority of the quorum is not a majority of the council. Majority of the quorum is 4. So a majority of the council, you'd need 5 members for anything, and I suggest, and I don't think you'd like it if all 9 of you were here and all of a sudden 4 people are making a major decision. Somebody's going to scream, but it's what your rules say right now, so that needs to be addressed. So to transact business legally, a quorum must be present. In most organizations, I tell them, don't write a majority of the members, because you'll never get the majority. If you got a 200-member organization, you had a membership meeting, you're never going to get a majority of all members. So what we propose is, on the worst night of the year, weather-wise, how many people can you expect to attend a meeting? Okay, so that's what you use as a guide. Now, under the not-for-profit law of the state of Illinois, I'm a parliamentarian, not a lawyer, but my incorporated organizations, I'm responsible for knowing what's in the law. The majority cannot be less than 1/3 of your membership, and for a membership meeting, a big membership meeting, it's 10% of the membership. So that's the guide in the not-for-profit corporations law. Other organizations, I just say, how many people do you usually get at meetings? So you can make decisions. And if you don't have a quorum, you can call the meeting to order and discuss other things that don't require action or a vote. And when your quorum shows up, then you can go back and approve the minutes, etc. Present one item of business at a time. The agenda will take care of that, Mr. Mayor. The next item of business is, so forth. And this is important. The assembly cannot be asked to decide a question twice in the same session unless the vote on the matter is reconsidered. If you've made a decision on something and the vote is over and you're going on to the next agenda, and all of a sudden somebody wants to go back and discuss what you just voted on, unless you're ready to reconsider the vote, that decision stands, okay? And reconsidering the vote is only good for that meeting, 24 hours. So apparently you're all familiar with that, so I'll just leave it there, that once the decision is made, unless you want to reconsider the vote, that stands. You may want to rescind it or repeal it at the next meeting, but not at this one. Okay, next. Silence gives consent, except when a motion is required. If you have an agenda item, let's say the minutes, and I'll cover those when we get to agenda. Silence gives consent. If you say, the first item on the agenda is approval of the minutes of the last council meeting. Are there any corrections? Not what I often hear. Are there any additions or corrections? No, you can't add anything that didn't occur at that meeting. So anything you do is a correction. Hearing none, silence gives consent. The minutes are approved as printed. This is how you adjourn before midnight. You don't waste. You might have a motion to approve the minutes. Is there a second? Is there a debate, etc.? Hearing no response, the minutes are approved as corrected. You can always go back months or years later, and maybe you thought of something that needed to be corrected, bring them up and correct them. And again, I've already addressed this. A majority vote decides a motion except when the rights of members are involved. Then it's 2/3, and I think you all are aware of what you need a 2/3 vote on. And again, the motions that deprive their members of their rights requires a 2/3 vote. For instance, motion to close debate, which you call the question. You're depriving members of their rights So that requires a 2/3 vote, and we'll go over that when we go to motions. Next. Basic agenda. You have your call to order. Do you have any kind of opening ceremonies, pledge allegiance to the flag, some pray, whatever? Roll call attendance. If that is your practice to have a roll call, you can look around and see who's here and who's not, and you can judge whether or not you have a quorum just by looking to see who's here. So you call the meeting to order. You can review and approve the agenda. Chances are they've had it in the mail somehow or another ahead of time. And if there are any changes to be made, you can make them at that time. You want to move something or you want to add something. And then, again, to save time, if there's no objection, are there any other changes to the agenda or additions? Hearing none, the agenda is approved as printed. And then, Mr. Mayor, you could say, based on whether or not somebody's late or not coming, that if there's no objection, the chair reserves the privilege of reordering the agenda as necessary. Because if you don't, and something happens, you need to go back because you approved it and get a 2/3 vote to reorder the agenda. So be prepared to say, if there's no objection, the agenda will be ordered as necessary, and you're the only one that can do that. And then approval of minutes of the last meeting. I noticed in your rules, you have approval of the minutes way down with the consent agenda. Yeah, the agenda has a logical progression from past to present to future. So after you call the order, the past is approval of the last minutes, or if there are two sets, you do them in order. The present, which is going on now, your reports of committees, etc. The future would be new business and the date of the next meeting. And then if you're going into executive session, you don't adjourn the meeting, you just say, that the remainder of the meeting will be executive session and people leave. But are you aware that if something comes up during your meeting and you have the need to go into executive session, one of you can make a motion to go into executive session and everybody leaves until that. Is that clear? You have the authority to do that. Okay? Some people will do it by making a motion to recess for 5 minutes and then they'll caucus. But always, if you're going to recess, tell people 5 minutes, 10 minutes, etc., and then you go back and reconvene. But things get hot and heavy and start going sideways, you can always move to recess, because the people who come here are observers. They can make speeches, etc., but they don't have any authority to recommend or whatever unless you give it to them. But one of you will have to make the motion for any action they want. But that's a way of keeping the peace. We have reports of officers, standing committees, and other departments that are related. Next. Special committees and task forces, special orders. You have something called special orders? Can somebody tell me what you mean by a special order?
Yeah, we do, Mr. Mayor.
So special orders are items placed on the agenda not pursuant to action of a committee. And there's 3 different mechanisms by which they can be placed on the agenda, and there's a lot more restrictions regarding the capability of holding them to a future meeting.
Okay. The other thing, all of that is, those are your rules which supersede anything else. But one way to make sure special orders are addressed, like at the previous meeting, if something comes up, you don't have time to research it and so forth. You want to make it a special order for the next meeting, but give it a time. What are your council hours, meeting hours, usually? 8 to 10 or 7 to 9 or whatever? Pardon?
Yeah, right. Unknown until tomorrow, basically.
Okay, but let's say the special order for 8 o'clock is, this is why I'm bringing it up. If it's 7:55 and you have a special order for 8 o'clock to deal with whatever, then at 7:55, Mr. Mayor, you say, The hour is 7:55. The special order for 8 o'clock is, which means everything stops and you go to that special order. That's why you put it there, to make sure you get to it. If you have more than one, then the next one can be 8:20 or 8:30. But as the hour approaches, it is your responsibility to say the special order for 8 o'clock or 8:20 is, and everything stops. And when that's addressed, then you can go back to the rest of it. But this is a way of getting things addressed that may be for that particular meeting or left over from a previous one. Any questions? Yes.
So our special orders of business limit the rights of members to vote on, to hold a matter for further deliberation, and we don't have a line for new business. So we kind of use, and I think somewhat inappropriately, special orders of business which limit the rights of members as new business.
That's okay. What did I say?
Well, yeah, certainly our rules, yeah, certainly.
Okay, and I'll get to that. So unfinished business, you know what, in general orders, do you know what unfinished business is usually called if you're at any meetings? Is there any old business? You've heard that. This old business is already taken care of. The reason it's on the agenda is it's unfinished. It came up at the last meeting or the meeting before, and you needed more research, so it's unfinished business, not old business. Now, new business. As I said, having been around this corner like 30 years, I've learned a lot from unions and everybody else. Don't ask for new business unless you know what it is, and I think you've addressed that. You would put things under new business, make them special orders, because that gives anybody the right to bring up anything they want and put it in form of a motion. And you know how to adjourn before midnight? It's 11:45, and you're asked to make a decision, and you want to get the heck out of here. So you're going to vote on it, and you're going to regret it because they deliberately put it under new business so you wouldn't have time to think about it. Okay? And then you're going to vote just to get out of here and get home and adjourn before midnight. So if anything comes up during the review of the agenda that's new, you can place it under new business before you even adopt the agenda. But if you have everything under new business, yeah, you can just say, there is no further new business, and somebody would have to interrupt you and say, oh, yes, I have. And one of you, and this is where I tell people, always be prepared. Have somebody say, we haven't had time to address that. Can we put it on the agenda at the next meeting? But don't deal with it tonight, because you'll be held accountable for any decisions you make in a hurry. Don't let people put you in a bind where you got to do something right away that you and only you will regret later on. Questions, comments? Yes.
I need some clarity on that one. So new business, because you're saying we could regret taking action on it. Voting on it because it's late.
It's brand new and you don't know about it and somebody wants to bring it up. Okay?
But they'd have to only bring it up for discussion, right? They can't bring it up for an action.
Bring it up, but yeah, they can bring it up for discussion. Because you have members, these people don't have any voting rights.
Right.
You have probably more authority than a regular organization. You can just say, well, that's a good subject. We'll put it on the agenda for discussion at the next meeting.
Okay, so yeah.
I'm just saying don't act on it.
Right, and I think our rules prohibit us from acting on it.
The Open Meetings Act would prohibit us from acting.
Right. This is why I asked the question in the previous session. The Open Meetings Act would prohibit final action on an item that's brought up that wasn't placed on the agenda. It would allow a variety of other types of votes to occur.
Okay? Yeah, and you see, you have an additional leg to stand on, which is the Open Meetings Act, okay? Okay, most of my groups don't have that because they are what they call deliberative organizations. They just meet to conduct their business, and if they're incorporated, they're under that one, nothing else. But you have two acts to fall back on. Okay. And then program, if somebody's coming to present something, and I always say, if you don't want everybody, you're a public body, so you go into executive session to discuss things you don't want everybody to hear. But if you have a program, that's optional. Have them present it there. or you can put it toward the front, wherever you want on the agenda, and then next meeting date, and you can just announce, the next council meeting is scheduled for, and then adjournment or go into executive session, which I believe is what you do. Then you adjourn after executive session, but everybody else is gone, right? Okay. Any questions on the basic agenda? Past, the minutes, present, future new business, next meeting date, etc. Logical progression. Okay? And then adjournment. And I'll mention it under motions, but you just adjourn, right, in executive session. In other words, you completed it. Okay. What I'm going to say, and I'll say it again later. My group, especially if I'm the new parliamentarian, is there a motion to adjourn? I tap or pull the sleeve I try to be inconspicuous. I'll pull the sleeve of the chair and say, you don't need a motion to adjourn. If you have completed the agenda, there's no other business to discuss. You just adjourn. There being no further business to come before this group, this meeting is adjourned. And, we parliamentarians are known for being strict and having no sense of humor, which is not true. So I say, okay, go ahead and accept the motion to adjourn. Get a second. All right, if it fails, what are you going to talk about? What are you going to talk about? So just end the agenda and send everybody home. That's how you adjourn before midnight. Okay, here we get into the nitty-gritty. Steps in handling a motion. A member makes a motion. If it requires a second, somebody else just says second. And you don't, unless it's your rule, you can put the name of the maker. Some people want the name of the seconder in the motion. And then the chair states the motion. It is moved and seconded that the city council will do so-and-so. Is there debate? The maker of the motion is given the right to speak first, and then everyone else. Okay, so they debate, discuss the motion. After all this is over, and the chair has no authority to close debate, you can talk. I mean, if you add a time like 5, 10, 15 minutes or whatever, but if there's no further discussion on a motion, Mr. Mayor, all you got to say is, seeing no one looking to be recognized, the motion before you is. And I had asked, do you write motions out? Because if you don't, I think I sent a form. I'll just send this around, because you can make your own. And this way the wording gets corrected in the minutes. Those are in 4 parts because as parliamentarian, I get the first one, the second one goes to the secretary, the third one goes to the person reading it, so that they have that form and the wording is exactly the way it was given in the minutes. You have your own copy, you read it, and if I'm sitting next to you, I'll hand you what they hand me and you read from it, and it just stays with the minutes until they're completed. So you can read it and say, the motion before you is, always tell your people where you are. Motion, seconded, discussion, no further discussion. The motion before you is that you do so-and-so. All in favor, if it's a voice vote, say aye. Those opposed, say no. Always take the no vote, because they're usually louder if they're serious about it. And then announce whether or not it's adopted. The motion is adopted and we will do so-and-so. If it fails, the motion is failed and we will not. If it's a 2/3 vote, you can't hear a 2/3 vote. So raise your hand, lower them. Those opposed, raise your hand, lower. There are so many in favor, so many opposed, the motion either passes or fails. So those are the steps. You make the motion, second the motion, you state the motion, you discuss the motion, they debate it, repeat the motion, and then take the vote, and then move on. The next item of business is. You notice I say item. What I hear frequently, and you probably do too, the next order of business is. The whole agenda is the order of business. It's the item of business is. Okay? Any questions on the steps in handling a motion? Moving on. Information on motions. The ranking motions, there are 13, 5 privilege, 7 subsidiary, and 1 main motion. Did anybody give you the motion chart I sent? You do have it. You have it? You do? No. Because it's important. As I go through these, everyone has it? You have it? It's easier for you to understand this because in the ranking motions, I'm going to go through them one at a time, and you'll understand in a minute why they're ranking. There are 13. Privilege 5, subsidiary. Ranking motions. On the form, you'll see they are ranked from the bottom to the top, the main motion being the lowest one because everything is done to the main motion. Okay? The privilege are more for the comfort of the assembly. What you'll see on the privilege is call for the orders of the day, which means that Mr. Mayor will just, that means somebody strayed from the agenda. Get back on to the agenda. No vote required. And recess or personal privilege, they're more for the comfort of the group than it is for conducting the business. And they rank higher than the subsidiary. The subsidiary does something to the main motion and so forth. Next. Click, click. Okay, the main motion. Look at the bottom of this form. Requires a second. You see all these little columns here? That's exactly what's up there. But this will tell you where they rank, and you'll find out in a minute why they're important. It requires a second. It's debatable, amendable, majority to adopt. It can be reconsidered. So you'll see the main motion. The next one. This is what we call secondary or subsidiary motions. They do something to the main motion. Postpone indefinitely. I'm not, all of these characteristics, I'm not going to read. We need the time to tell you the reason for this motion. This is the motion when you want to kill something. You're not familiar with the term indefinite, but if you know you don't want this, and this is the motion that requires a second debatable. It's not amendable because there's nothing to amend. In order to amend a motion, it has to have a variable. Time, place, money, person, number, whatever. Majority vote, and it can be reconsidered. Now, why would you want to postpone something indefinitely? If Commissioner Burns has brought up something you don't want to do because the last council and the council, those of you who've been around, you know that this is not a popular thing and the people of Evanston wouldn't stand for it. So rather than waste all that time debating it and amending it, you know it's not going to pass, so you would move to postpone indefinitely, which is to kill it. If that motion is adopted by majority vote, that's the end of it, it's dead. However, now this is by example because I'll go over it. There's nothing to amend, but if somebody jumps ahead and decides to refer it to a committee, you've got to deal with the vote to refer where it says commit. Then if that passes, then this motion goes to the committee, okay? If it's postponed to a certain time, you say, in other words, the reason they're ranking as if you want to make the one above it, that's the one you got to deal with before you can come back to the one below. So if nobody makes a motion after postpone indefinitely and you take the motion on that, it's dead. But they can't make amend because there's nothing to amend. But they can commit it, they can postpone it, they can close debate on it, it's debatable, or they can call the question on it, or they can table it, which means that it's only tabled till the end of this meeting. But if you vote it down and nobody else makes a motion, then it's dead. The next item of business is. Any questions on postpone indefinitely, which is to kill? Many people will use the motion to table, which is kill. Now, under Sturgis, or the Standard Code, which is the other organization, American Institute of Parliamentarians, when they want to table something, they mean to kill it. But that's another authority. It's not Roberts. So this is to kill, and that is the end of it. Do you understand the ranking, that every time you make a motion above it, you got to deal with that one before you can come back? Yes.
I just want to note for our council, I believe we have a rule that does not allow us to postpone, to table something indefinitely. I think our rules say that.
Postpone indefinitely. If your rule says
yeah,
you don't,
yeah.
then you don't do that. So in other words, you got to deal with everything that comes up. That's good. Okay. The next one then. Now here's the one that probably we're going to spend a couple of minutes on. This is the amend. That means you do something. You want to change something or modify the main motion. It's debatable.
I'm sorry.
Yes.
I'm a little slow this morning. I'm not sure I fully understand the hierarchy here. What the order within the list of subsidiary motions means. Do you mind?
That's why they're called ranking. That if somebody makes a motion, all right, the main motion, and then somebody else doesn't like it and they move, like you said, you can't postpone indefinitely. But if there's a variable in there, then somebody wants to amend it, and we're going to have an exercise on that in a minute. But if somebody else reads, well, I don't want to deal with amending it right now, I think we ought to send it to a committee. You can either send it to a committee that already exists or create one. But what is it that you don't understand?
Let me say something and tell me if I'm right or wrong. So when a motion on this list has been made but not yet voted on, it is then in order to make a motion higher up on the list but not lower on the list. So if someone were to try to, let's say, postpone indefinitely, presuming that were something we allowed, prior to that vote, someone else might make a motion to commit.
Exactly.
Thank you.
Yes. In other words, as long as that motion is not voted on, this is why if you want to do something else to it, you got to make that motion before it's voted on. So you immediately jump to the higher one. But if it's sent to a committee, then everything goes to the committee and you go to the next order of business. Okay? So they're made going up. But if you get all the way to table and you can't debate it, then you got to, if it's, I say table, the proper use of the word table is to put it aside because something else has come up. But then when that is dealt with, maybe a special order, then you have to take it from the table and then go back to it. But you have to do it at this meeting. And then once it's taken from the table, then you go back to the previous question if that came up, or whatever motion. You make them going up, you process them coming down. Okay? I think we did that at the meeting because there were enough people here, I think about 30 that night, that I gave everybody a special motion and had them make them going up. And then I told them the same motion coming down and how we got back to the main motion. By that time, it had been amended. Okay. This requires a second. It's debatable. As I said, if it contains a variable, time, place, amounts of money, etc., it's amendable. And then a majority vote can be reconsidered. Now, since people have, at least in my experience, the most trouble amending a motion or amending an amendment, I have given Councilman Reed and Burns, you have the primary amendment, and you have the secondary, and Councilman Braithwaite, I want to say Councilman Braithwaite, you have the main motion. And I decided yesterday to try something that you were familiar with. So, okay, this is an exercise on the motion to amend. Would you read the main motion? And I'll process it instead of asking you and then, okay?
Yes. Members of council, I'd like to move that the 2021 community picnic be held on Sunday, August 22nd from 1 to 4 p.m.
Okay, I know that because I usually work the food court. Is there a second? Just anybody, just yell out second. You second. All right. It has been moved that the 2021 community picnic be held on Sunday, August 22nd from 1 to 4 p.m. Is there discussion?
Yes, Madam Chair, I move to amend the motion by striking August 22nd and inserting August 29th.
Is there a second? It has been moved to amend the main motion by striking August 22nd and inserting August 29th. Is there discussion? Would you like to speak to your motion? Okay, is there discussion? Yes.
I move to amend the amendment by striking August 29th and inserting September 5th.
Is there a second? Anybody? Okay. Does anybody want to second that? Because if you don't,
It fails.
it fails. Now, this is what I hear most frequently. The motion dies for lack of a second. It doesn't die. It was never born. There is no second, so it's not before you. So we're back to the First Amendment, which is to amend the main motion by striking August 22nd and inserting August 29th. Is there discussion on the primary amendment because the secondary failed? Yes.
Well, then I would say there's a reason why I selected August 22nd, and the 29th doesn't work for a variety of reasons. Or that would be the discussion part of
Okay.
it.
All right. So any other discussion? So then the secondary amendment died or was never born. So the primary amendment is that we strike August 22nd and insert August 29th. Any further discussion on that? All in favor, say aye.
Aye.
Those opposed, say no.
No.
The chair is in doubt. Would you raise your hand, all in favor? 1, 2, 3, 4. Hands down, all opposed. 1, 2, 3, 4. Mr. Mayor, it's up to you. No, because there's a tie vote.
Yeah.
Oh, all right, so the motion fails, and we're back to the original main motion. Now, if that had passed, I'd be reading the main motion as amended, which would be August 29th instead of August 22nd. Do you understand why I want you to go through this? Because you can have 2 amendments to every main motion, then you have to stop. So it's the secondary motion, if that had passed, and it's the primary amendment as amended, and if that passes, it's the main motion as amended, and all of that. But I wanted you to go through that, but you can start all over again after you finish, and then say, well, I think it ought to go to 2 to 6, so forth. Yes, you got a question? You have to approve the amendment and then approve the motion. As amended. So in other words, if you had approved the secondary amendment, then the primary amendment would be amended to read September 5th and so forth, and you work your way back until you get to the main motion as amended. And the reason I wanted the exercise is so that I could show you how people would get confused, because you got to tell people where they are. Because after they voted, what did we just do? You know, so you have to do that. And some people will just say, I move to substitute the whole thing by saying we have a barbecue on September 10th. And then you got to look at the picnic, the barbecue, and then vote on that, but we ain't going there. Yes, question?
Yeah, did you just say that you can't nest amendments beyond twice?
2 at a time.
Got it.
2 at a time. However, once you have done that, you could start all over again with another amendment, but it has to be different from the one you just adopted, because you can't ask a group, that's one of the principles, to decide the same question that's been decided in that session. So you would have to deal with the time, or whether you wanted to have the picnic at all, but you couldn't go back to the 22nd, the 29th, because you've already decided that.
Can I ask for clarification about the definition of 2 at a time?
Yeah, the primary and secondary amendment is really what it is.
So, motion is made, primary amendment is made, secondary amendment is made, secondary amendment fails. Can another secondary amendment be made?
Yep.
So, got it. Thanks.
But I didn't want to give you that because I figured this is all new to you. So, but yes, you can do with the secondary amendment. In other words, you're amending the amendment. But no matter what, only 2 amendments at a time. Then you process those, but you can start all over again. Any other questions on amendments? Yes.
So given all that, before we get to the vote, what if I wanted to send it back to committee? Where would I do that at?
Well,
So
you're
we have
still
to-
dealing with amendments, so you would move to send it to a committee.
Would I
And
do that?
all those amendments would go to the committee with a motion.
Would I do that before we vote on the
Oh,
amendment?
look, you better.
Okay, so I just want to make sure. So
Because
as
once
a,
you vote on it, the decision is made. So while the discussion is going on, you make the next highest motion. Yes.
okay,
So with Councilmember Fleming's example, if the amendment is adopted, can she make the motion to commit before the motion on the vote on the main
Before
motion?
the vote on, you could send the amended motion to a committee.
so I would
Okay.
make that motion during the discussion.
Yeah,
Got
yeah. So in other words, as long as we're discussing this, you make the next motion before any vote is taken. Because once the vote is taken, okay, the vote on the amendment, but if you wanted to send the amended motion to a committee, you make the motion to commit, in which committee to send it on. And on up the line, if you wanted to close debate and so forth and all of that, but don't forget, you're only closing debate as long as amendment. It's only on the amendment, not the main motion, because you're still discussing the amendment. Okay, yes.
Can I just, because I'm still slow this morning, can I just,
But that, you know what? This is why I decided to spend some time on reading, for the very reason all of your questions are coming up. So go ahead.
so my understanding is that Councilmember Fleming's got two choices. She can, when the amendment gets, when the amendment is moved, she can immediately move to refer this whole jumble.
The whole jumble
Which is
of
to
the
say,
commi-
the underlying motion and the amendment together, though they've not yet been married by a vote, to a committee to talk about whether they want to
And
adopt
bring
that
it back.
amendment. Right.
And you tell them when the committee is to report at your next meeting.
Or she can wait for us to vote on the amendment, then the motion has been changed, and then that amended motion as a single unit, she could then move to refer to committee. Do I have that right?
Exactly, exactly.
Thank you.
Any other questions? Is that clear to everyone about amendments and committing and the next highest motion? As long as you make that motion to go to the next level, commit or postpone definitely, which means to another meeting, as long as the vote isn't taken, you know, as I said, with this, the amendments go to the committee, those that aren't voted on, along with the main motion. Okay. That's why they're called ranking. Each one outranks the other.
So if somebody makes a motion that's higher up on the order, we're
To deal with that
obligated
first.
to vote on that motion before considering.
Exactly. So you make them
The lower
going up.
number.
You vote on that motion, and then you start coming down unless somebody makes one even higher until you get up to the point where you're tabling it, which means that you're putting it aside or, you know, you're taking a final vote that's either passes or lost. So that's why they're called ranking motions. But you see, you wouldn't see that on here. This is why I gave you the chart, so that you can take these to any meeting, and you don't like what's going on, you can start using these ranking motions to do what you want to do.
So these are the ranking motions according to
The
Robert's
ranking
rules.
motions,
Right,
the
so
ranking
do
motions start with the
city,
main motion,
do
go all
city-
the way up to lay on the table.
do city council rules say anything differently? Is this list any different if we look at the city council rules?
You can choose to use these or not, your council.
That's my
rule.
question.
But if your council rules are silent on, but this is where parliamentary comes in, because you can always use these, you're still processing motions. But I don't see how, you know, what wording you would use to get these in. This is why wherever your rules are silent, your parliamentary authority, Roberts, kicks in, and this is Roberts, okay? Okay, any questions on amend and sending to a committee and ranking motions? Okay, we'll go to the next one. Postpone to a certain time. Okay, what we're doing is saying, well, we don't want to deal with this at this meeting. Why don't we just move it to the next meeting? So it requires a second, it's debatable. Well, we don't have time because, you know, August and September's coming up soon and we're not going to meet and so forth. So you may decide to vote against postponing it. Okay? The next one, number 5. Limit or extend limits. All this means is, you know what, we got a full agenda tonight. Let's not spend more than 10 minutes on this issue. So you can move to limit debate to 2 minutes or 1 minute per person or 2 speakers or 15 minutes, any way you want. But because it involves, this is why I went over the principles first in the rules. Members have a right. Anything that deals with the members' rights requires a 2/3 vote. So you would have to approve this by 2/3 to limit debate because you're taking away a member's right to debate or speak. The next, number 6. You know that the previous question is, you mentioned previous question in your rules. Yes.
That last one, is that 2/3 of the quorum or 2/3 of the council?
Well, if you do 2/3 of the quorum, are you satisfied with 4 people making a decision when 9 of you are present?
So the rules.
So what I'm saying is your rule right now says that a majority of the quorum can make decisions. Your majority of the quorum is only 4 people. A majority of the aldermen present, say they're 8 or 9, would mean 5. Okay, so in other words, it's a majority. That's why I suggested, and you can do what you wish, but I'm just saying from a parliamentary point of view, you're letting a minority rule you when you go with the majority of the quorum. So the quorum is one thing. You go with the majority of the aldermen present. Because what I said before, if 9 people are present and 4 of you are deciding, you're not going to be very happy about that. Okay, so revisit that question of a majority of the quorum. I'd say a majority of aldermen present.
Not the majority of the quorum. It was the majority of the aldermen present for the majority of all the council members.
How many have voting privileges? 9 and the mayor to break a tie. And on certain other things, I think. So it would be the voting members of the council. Previous question.
So lower attendance doesn't decrease the threshold.
Pardon?
So lower attendance doesn't decrease.
Well, you know, when you only have 9, you're...
Our rules for limiting debate require a majority of the city council, not necessarily those present or a quorum. It's just the majority of the council.
That means majority, whether they're present or not, a majority of the council is
5.
9. If you add the word present, then you're dealing with those that are present. If you say a majority of the council, okay, then you're talking about 5, because according to this sheet, majority of 4, let's see if you have 4 or 5, so it's either 4 or 5 because you're small. If you were a larger group, the quorum required is, you know, is a larger number. This is an example of 2/3 and 4, and that's the only card I have. How to calculate 2/3 and a majority.
I just
Yes.
want to know, our body, the mayor is considered a member of the council, and so maybe it would make sense to say of voting members, you know, in certain cases, because with him it's 10 on everything.
10,
and
yeah.
so majority.
The majority of, see, the mayor, you vote in case of a tie. Aren't there other situations where you are allowed to vote ordinances and so forth? Okay. Not a lot. But if those questions were to come up, then it is whatever the vote is required for that particular item. Okay. Any other? Okay, previous question. Y'all know what this is called? You know what you call it most frequently? I call the question. In other words, you call for the question, which means you want a vote on the motion immediately pending, which, just as I demonstrated, may be an amendment to an amendment. So when you call the question, people think it's on any motion it's on the main motion. No, it isn't. If you have a secondary amendment, it only calls a question on the secondary amendment or a primary amendment. Again, it requires a second. It's not debatable, not amendable, requires a 2/3 vote because you're taking away the right of a member to speak and can be reconsidered. That is, the vote reconsidered. Somebody can bring it back. We'll discuss that later. Number 7. Lay on the table. As I said, other authorities and organizations use this to kill. In Roberts, lay on the table is to put aside something to take up something more urgent, then you take it from the table, and it's your responsibility, Mr. Mayor, at the end of the meeting, you need to keep track of anything that was laid on the table, because if nobody else brings it up to take from the table, a motion to take from the table, you say, earlier in the meeting, we table such and such. So that it doesn't die at the end of this meeting, it's your responsibility to bring it up, that earlier in the meeting, we laid aside such and such, it's back before you. So with no objection, you are taking it from the table, because it's your responsibility to remember so it doesn't die at the end of this meeting. It requires a second. It's not debatable, not amendable, majority vote. The way I remember it in the many tests I've taken over the years, there's no debate on the top 8. The top 8 starts with lay on the table, which is limit debate. It's the rest of these plus the privilege motions. Okay, any questions on lay on the table? If you put it on the table, you take it from the table.
It may be worth mentioning that I don't, just in terms of our council practice, that we haven't exercised this, Mr. Mayor, in most meeting settings where we'll put something to the back, but I think it's the opposite, whereas if something is, you have a number of people in the council chambers to vote on whether or not we move forward with Pet Cemetery, then you would, or someone from the floor would ask that we move this up. We've done that for kids' presentations, et cetera. So if there's like a large swell or people are here, we just, out of courtesy to those that are here, we'll move something up versus moving other things back, is what we've normally done by council practice.
You are correct, but you know where that fits in? Reordering the agenda as necessary. That's the reason for discussing rules and basic principles before I started on the motions. That as necessary, and for the subject matter you say, a lot of people taking time, then the chair can reorder the agenda as necessary, because he said so when you adopted the agenda. The agenda is adopted. If there's no objection, the chair will reorder the agenda as necessary. Then it's necessary. If he doesn't say that, then somebody have to offer a 2/3 vote to reorder the agenda. It comes under the motion to adopt, to amend something previously adopted. So get those words in, and it saves you a lot of time, and that's one of the reasons you can adjourn before midnight.
Can I ask a follow-up question? Because I think our past practice is just, it's more of a courtesy, so I don't recall if we've ever voted on moving things up.
If there's no objection, no, you haven't voted.
Fair
That's
enough.
what I mean by,
Fair enough.
that's courtesy. If
Yep.
there's no objection, the minutes are approved. If there's no objection, the agenda will be ordered. If there's no objection, we'll extend whatever. So if there's no objection, covers a wide variety of things. And it's just a few words, and it saves a lot of time. Okay. Now, those are the motions that do something to the main motion. Yes?
All right, I have a question about laying on the table. I think I'm confused. So if I make the motion to lay something on the table and it gets a second and we go through all the voting, we have done that, I thought, in the past, and I know you just mentioned this, I got confused, to either kill it or deter it, not necessarily for the same meeting, right? And so you're saying at the end of the meeting, the mayor needs to say, this was tabled, now let's bring it back up, and that is not what we've done before, is that correct?
Can I add something on? Because I know where she's going. I think the key point in this is it may not be sending something to the bottom of an agenda, but it's, the key point is setting something to the bottom agenda, but you may be, and if you're not, I'll stop. I'm more curious is to define laying something on the table versus holding. So there's a...
No, because I think we've used the tabling, in my recollection, we used the tabling almost as a holding.
That's why
So,
I'm asking for the
yeah.
distinction.
So the city council rules for laying on the table require it to be laid on the table to a date certain.
There it is, yeah.
But she is telling us we're supposed to lay it on the table and revisit it. I know our rules.
And so under Robert's rules, when you lay something on the table, it's laid aside for that meeting. But our city
Under
council
our
rules say that you can lay it on the table for a date certain.
Okay.
That's postponed indefinitely. If for a date certain is postponed indefinitely, and that's further down. lay on the table what I said under Roberts, unless you have your own rule, you put aside something to take up something else that may be more urgent. Maybe you got a speaker who has to catch a plane, or somebody is going to be late being here. So whatever you're discussing is laid on the table until you finish this, out of courtesy to the current speaker or whatever. Then toward the end, so you don't forget because you've taken care of other business, you would say earlier in the meeting, we laid on the table the discussion on or the motion to, and you go back to it.
So we need to change our rule language.
Correct.
If you want to, but I mean.
But we should, because it's confusing if
it's confusing, then now you know what to do. You have the chart.
Right.
You know, and this little book I told you about will tell you about it.
Right.
That you put it aside temporarily to take something else up, and then you go back to it before the end of the meeting, because you're bound to forget it.
Our rules, as you've stated, supersede this chart, so I think it would be very
Yes.
helpful to me, and I assume to many others, that it would be nice to have a City of Evanston version of this chart.
Anything, you have Corporation Counsel, okay? Anything that you may be confused on, discuss it with your counsel, okay? But remember, as long as you're not breaking a law or violating anybody's rights, you can do what you want to do, okay? These are just the guide for when things aren't covered or unclear.
I think
Yes.
Councilmember Reed, oh, sorry. Let's go with Councilmember Reed and then Braithwaite.
I just want to note, I do think that there is, as we were discussing, a conflation between laying on the table and postponement in our rules, and I do think it would be, as Alderman Fleming suggested, prudent to clear up that conflation between laying on the table and postponing.
Postpone is to a date certain. Move to postpone the next meeting or at a committee meeting or sometime in the future. Table is to put it aside for this moment. Postpone, okay. Reorder, if you want to put it later on the agenda, then you're reordering the agenda. That's not postpone definitely.
Right.
Many people, as I said, will use postpone and to kill, they will say table. Postpone, they would table something until the next meeting. No. Table is to put it aside temporarily. Postpone, and I'm always yelling this out, especially to a group downtown that's always using table, and I'm yelling postpone because they want it at the next meeting. Okay, but again, your own rules supersede, as long as you're not breaking any laws, and you know that better than I do. But if you want the correct definition of these, then maybe you need to look at them and decide, do I understand table? Do I understand postpone definitely? Do I understand postpone indefinitely, which I said is just a motion to kill? Because you notice that it's right above the main motion, and if it's killed, it doesn't go anywhere. The others do.
And just to clarify, if something is tabled and not brought back up for discussion prior to adjournment, it is in fact killed, correct?
For that meeting, they can bring it and put it back on the agenda at the next meeting and make it a special order.
Sure.
If you forget to bring it up and nobody else remembers that we tabled something, and if that subject was important to somebody at that time, that person can remind that it was tabled. Yep. If nobody else does, then you should be aware that something was tabled or laid on the table earlier in the meeting, and if they're, we'll take from the table, otherwise it's dead for that meeting, but you can always put it on the next agenda.
Yeah.
Yes.
We'll go to Councilmember Braithwaite and then Kelly Kandersky.
I can't hear you.
Over the years, what we've seen, why I said this is a great conversation to have, is we have our city council rules, and then we have Robert Rules of Order.
And I've reviewed them both.
Typically, we see a conflict.
But that's up to you to resolve, not me. I'm just telling you what's what from Roberts. You know your rules. It's up to you to reconcile them.
Well, crystal clear. I mean, so before we launch we're already on our journey, but I guess my point is to Nick, city manager, and also the members of the council is, while we're having these debates, we can suck up a lot of time going back and forth just on the rules and not the substance of what we're discussing. And so I don't know what the shortcut is, or excuse me, maybe not shortcut, but the most efficient way to get to when we all of a sudden stop debating the substance, but now it's a question of Robert's rules versus our city council rules in order to advance something. And I'm not sure if
your city council rules would come first.
Always. And then
Always.
the corporation council would be the authority on the city council rules,
Mhm.
just so we're all clear.
Yeah.
Okay.
Yeah, it's your own rules, because even your rules, and in other cases, bylaws say, Robert's Rules of Order shall govern the business of this meeting except where they are inconsistent with these rules. And I have to, just a month ago, I did a Zoom meeting with an organization that said, they hadn't read that line, and I underlined it and said, but it says where they are inconsistent, because they thought they were in violation of Robert's rules. I said, but your own rules say, except where they are inconsistent with the rules of this organization. So that line means an awful lot, but a lot of organizational officers don't understand that they got the answer right there. Okay, now any other questions on the ranking division?
I wanted to note on the issue of table, Robert's rules does state, you can correct me if I'm wrong, that if it's not tabled to a date certain and it's not pulled from the table in a subsequent meeting within 120 days, it is in fact a dead issue.
If that's your rule.
I believe that's also.
Well, again, don't confuse postpone definitely with table. They're two separate motions. One is debatable, one isn't.
Right. So I just
One
wanted
is
to note
amendable,
that
one
there is
isn't.
a time limit on the table.
There is, yeah. But again, follow your own rules. Now, any other questions on, see, those were the subsidiary, and it was important to discuss them because they rank as we go up. Okay, if not, we'll go along to privilege motions. Now, these come up, these are more for the comfort of the assembly and the conduct business rather than hierarchy of motions. So, privilege motions, the first is call for the orders of the day. I'll make this really brief. All that means is somewhere you got off the agenda and all you got to do is say, Mr. Chairman or Mr. Mayor, I call for the orders of the day. That tells you we got off the agenda, get back to it. That's it. Next one. Question of privilege. Well, maybe somebody's sick and you want to send them flowers. Or it's your birthday and they want to sing happy birthday to you. So you ask a question of privilege and no second is required. It's not debatable, not amendable. You can interrupt the speaker, but all you got to say is, you know, it's the mayor's birthday. Let's sing happy birthday to him. Nobody objected that, so you sing happy birthday and go on with your business. Next. That's raise a question of privilege. Recess. Requires a second, not debatable. It's amendable as to how long you want to recess, 5 minutes, 10 minutes, right now, later on, etc. Majority vote, you can't interrupt the speaker. This is one you can't. Now, if a recess is already built in, I don't think you have to worry about this, but maybe somebody will feel like, I think we need a 5-minute recess. Now, I'm going to share something with you that isn't written anywhere, but I know where it is in Roberts. If you feel that the situation is so hot that you need to talk to your folks right away, you can say recess, but Robert's term for it, because see, recess, people leave the room. If you want them to leave the room, you can say, we'll recess for 5 minutes, 10 minutes. And then council members, would you come here? I want to talk to you. But if something comes up and the situation's getting hot and heavy and people just need to lower the temperature, Robert's rules say, you just say, stand at ease. Stand at ease means you just stop where you are, you don't leave the room. Everybody cool down, take a deep breath, and then go on with it. But the term, if you don't want them to leave the room, is the assembly will, or the council will stand at ease. Otherwise, recess, people can leave, but you can still tell them you want to talk to them. But the term is up to you, whether you want to recess or stand at ease. Stand at ease means nobody leaves. This only take a minute or so, okay? But if a recess is built in, but you vote on that, and you vote on how long the recess is, that means it's amendable. Questions? Pardon? You can say recess for 5 minutes, but you can amend it to 10, or you can change it to 2.
Stand at ease is new to me, and I thank you for sharing.
That's why I brought it up, because you don't know about that, but that's what we mean. This is why we change Robert's certain principles every 10 years, because this is the biggest this book has ever been, because the last You know what all this deals with? Electronic meetings. Because we had to add electronic meetings because that's how everybody's meeting. I've told my clients who are incorporated in Illinois, don't worry about your bylaws, because unless your bylaws say specifically that you cannot meet electronically, then you can. But the not-for-profit law says that you can, so don't worry about it. But next time you amend your bylaws, you can put it in there. Yes.
So my follow-up is, do we define the time period with the stand of ease? That was the one part that I missed.
Yeah,
Okay.
you can tell them stand at ease for 2 minutes, 5. In other words, recess means that people will
Got
leave
it.
the room. They know that. But if you say stand at ease, just say stay where you are, and we'll talk for a couple of minutes.
Thank you.
Wait,
Yes.
is stand at ease a motion, or is that just the discretion
No,
of the chair?
that you just declare, we
Yeah.
will stand at ease. You can call that anytime you feel the temperature rising, so to speak. In other words, you're the peacekeeper. And you're just giving everybody a chance to settle down, and stand at ease is usually when something comes up, or if I'm sitting next to you, say as a parliamentarian, and you need to discuss something with me, you'll say, stand at ease, I need to consult with the parliamentarian. That means don't leave the room. But you can say that if you want to do that. Yes?
Question regarding the motion to recess. How can that be amended if it can't be debated?
It can be amended as to the amount of time. That's why I say it's time, money, people, places. So if you can say, if a person says, I move we recess for 10 minutes, and somebody else wants to amend it to 5, then you vote on 5 or 10, et cetera. That's why it can be amended.
That doesn't count as debate.
No, you don't debate it, you just change the time. It's amendable but not debatable.
You can move to amend before the question is called to vote. Councilmember Newsma.
Before, but you have to do that before you take the vote on it, because once you take the vote on it, the recess is right away unless you say a future time at 11 o'clock or 12 o'clock or later. Okay?
I had
Next.
one more. I had one more question.
Yes.
But for us, because we're governed by the Open Meetings Act, when we move to recess, we can't discuss council business.
Okay, then
And
if you move to recess, you can't, then you don't recess. But you can stand at ease.
But also during stand at ease, we can't talk.
Okay,
Unless it's
but
public.
maybe you're not discussing council business, but maybe you want to discuss how to keep this crowd quiet. Is that, what, the council business is whatever you say it is.
Well,
But remember, no matter what I say, as long as you're not breaking a law, your rules come first.
Right.
I'm just saying that for all other organizations, there isn't a Roberts for different organizations. You have to decide what you want to do and whether or not this fits in with your plan.
Yes.
Okay?
Okay,
Yes.
thank you.
And I wasn't sure if you respond. I think it doesn't happen very often, but if we're having a conversation, we may lean over to someone
That's
if there's
okay.
a clarification, or walk over to something if
Okay, you
somebody
can
needs
do that during a
clarification.
meeting without either standing at ease or recessing.
Correct.
If you're comfortable doing that
Right.
and that's appropriate, then stick with that.
Right.
Okay.
So for new members of council, that's just, what I'm stating is, every once in a while, if I'm having a conversation with Councilman Newsma, and there's a clear misunderstanding, I can come to you and say, this is not what I'm trying to explain. I'm trying to explain this. And then that could save time in a meeting. So often, if there's one word or a phrase that throws the whole meeting off, I can pull it back together with just a one-off conversation with you.
Now, what I do when what we call deliberative organizations and non-legislative and not open or are responsible to open meetings, I will, if things get hot and heavy, I'm sitting next to the chair of the meeting, and I'll say, you need to talk to me. I'll slip my piece of paper.
Yeah.
And they'll say, would you stand at ease while I confer with the parliamentarian? And now they know that's serious, because, see, people don't see me, or they see me, but they don't hear me, that if he's talking to me, there's something big going on. And usually, all we need to do is say, would you like a hamburger or a milkshake or something like that? Because when people see us conferring, they know that they're misbehaving and they need to cool it. Okay? And most of the time, when they see the two of us conversing, it's, oh my God, we're being bad, we better shape up. Okay, next.
Very quick thing.
Yes.
Very quick thing. I wanted to say something, but just in response to what you said, majority of a quorum. So we could have 3 or 4 members. I'm sorry, Alderman Nguyen. We could have 3 members have a discussion at a time, just with the
Yeah,
Open Meetings
as
Act.
long as it's just a discussion.
But my question was raised earlier about the interpretation of the rules. I think there might have been some confusion. So as the parliamentarian or the corporation counsel or whoever the council designates as our parliamentarian, ultimately the chair and the body interpret their own rules. The parliamentarian provides advice. And
The parliamentarian provides advice. You can take it or leave it, okay? But I'm just there, you know, what I hear and have to correct people on, like in Congress, the parliamentarian does not move. You're not elected, you are hired help, okay? You're a consultant. They can take your advice or not take it. Most of the time, they regret not taking it.
Right.
But in other words, they don't have to go along with anything I say because I'm there to advise.
And then the body can overrule the interpretation of the chair with a majority vote, correct?
That's what, you'll see a motion on here called appeal.
Yeah.
I'm not going into those because we could spend 2 days on
Certainly.
incidental motions, but that's when you don't like the decision of the chair, you can move to appeal, okay? But we're not going into that. So we're on adjourn. I've referred to this already. If you have an agenda that you have completed, as I said, there's no more business to come before the assembly. This meeting is adjourned. You don't need a motion. But if somebody tries to make one, then they got to follow it through. What I hear most frequently, and it's kind of funny, somebody will say, can we have a motion to adjourn? Yes, second, and everybody's out in the parking lot. If you're going to have a motion to adjourn, follow it all the way through. But if you don't need it, don't make it. Okay? But most of the time, the adjournment is built into the agenda. Now, the next one, fix the time to which to adjourn. If for some reason you don't complete the agenda for this meeting, you, Councilman Reed, can move to fix the time to adjourn this council meeting till next Tuesday at 7 o'clock. And you will complete this agenda. So you move to fix the time to adjourn this meeting, so everything isn't going over till the next month or the next meeting. So you're continuing this meeting to complete the agenda that you had for this meeting. That's why this is the highest of all meetings, is to fix the time to adjourn this meeting. Yes?
That's an adjournment and not a recess, so it comes with some Open Meetings Act ramifications.
Recess has to do with this meeting. Fix the time to adjourn is continuing this meeting to a future date so you can complete the agenda.
Excuse me, we have 15 minutes for this item on the agenda.
Okay, okay, we got 15 minutes? Well, apparently they have a lot of questions, but we have 15 minutes so we can continue. I'll go through the rest. But in other words, this is the last of the motions which carry most of the discussion and that we need to address. And I decided to give you the form so you can keep it in front of you so you know what is debatable, amendable, what proceeds, and other, et cetera.
So since we're on this point, because I think it's an important one for those of us with families and other obligations in the morning, if we set a time for 11 p.m. midnight at the top of the meeting and we go beyond that, then that would require...
Fix the time to adjourn.
Right, that at 12 o'clock we're done unless there's a motion to extend
Fix
the time
to adjourn. And the chair can say, you know, we've had so much discussion tonight and it's really important that the chair will entertain a motion to fix the time to adjourn. The chair doesn't make motions. So one of you have to pick up that clue and fix the time to adjourn this meeting, okay, to a date certain, which is before the next meeting, the next regular meeting, okay? Okay, next slide. We can go a little faster. These are restorative motions. I'm just going to mention, we all know what reconsider is. You've done it here. Okay, you're bringing back something that you maybe voted on hastily or you got new information and you bring it back to reconsider the vote. You can't do it on the last day of the session. You've been in the state legislature where you reconsider and enter into the minutes, which means that it is, and it usually happens I've been a lobbyist, so it usually happens on the last day of a session, which means that if something is reconsidered and enter into the minutes, it's dead for that legislative session. Okay, the next one rescind or appeal. Maybe you made a decision at this meeting that at the next meeting you have more information and you realize it wasn't a good one. But if you notify people ahead of time, it's only a majority vote to rescind or repeal a decision that was previously made. If it comes up during the current meeting, it requires 2/3. So it requires debatable, amendable, and take from the table. I think we have run that one into the ground. You put something on the table, you take it from the table. I was at a parliamentary conference, and somebody from Toastmasters was a speaker, and he said, you know, parliamentarians and presiding officers are the only ones that can take something from the table and put it on the floor. And what they mean is, we talk about putting food on the floor. We were at a banquet. You put it on the floor, mean it's before the group for discussion. But he was trying to be funny by saying, we're the only ones that can take something from the table and put it on the floor. You're putting it back on the floor when you take it from the table because you have to act on it. Okay, rules of debate. The maker of the motion has the right to speak first. Okay, after it's seconded and stated by the chair, you speak first. No member may speak a second time to a motion until every member who wishes to has spoken once to that motion. As parliamentarian, some groups I know well enough to be able to keep a list so the chair knows Mary has spoken or Dr. So-and-so has spoken and so forth. And, you know, you've spoken twice already. You can speak twice too. Now, that's a question, not a main motion. It can be an amendment or a secondary amendment or whatever. So you can't speak a second time. This is courtesy. Okay, all remarks must be limited to the merits of the motion immediately before the assembly. This is why I concentrated on amendments to the motion, because what's immediately before the assembly may be the secondary amendment, the primary amendment, or the motion as amended. You can't go off into something else because you will be ruled out of order. The member's never out of order. The comment is. Okay? The merits of the motion immediately before the assembly. A member may speak no more than twice to the same question on the same day. They can speak twice to the secondary amendment, twice to the primary amendment, twice to the motion as amended, etc. And each speech, usually 10 minutes is what Robert says, but most often it's 2 or 3 minutes because you'll be there well after midnight. Personal remarks must be avoided and motives of members must not be questioned. I don't have to tell you that. The public is usually here looking at you, so behave yourselves, okay?
10 minutes left.
We'll do it. All remarks must be addressed to and through the chair. They're only talking to you, Mr. Mayor, not to, you know, Councilman Kelly or anybody else. Members should not be referred to by name, Councilman, this, that, whatever, Mr. Mayor, etc. A member may, here's a good one. A member may speak in debate and close by offering a secondary motion. What that means is, Councilman Burns, you can get up, debate a question, say what you have to say, and before you sit down, you can call the question, which means that you're offering a motion to close the debate. All the rest of you are going to get mad because he said what he had to say and he wants to cut you off by offering this motion. Number one, vote it down, or else in your rules, I don't remember reading them, but I would look at them anyway. You can say a member may not speak in debate and end by offering a subsidiary motion, such as call the question. You either debate and sit down, but the principle in parliamentary procedure and in Roberts is when a member has the floor, they have it for all legitimate reasons. Speaking, debating, voting, etc. So unless you have a rule that says that they may not speak and then end by offering a motion, most often to close debate, then they can do it. So I would think about the word not. I don't know whether you address it or not. I don't think I saw it there. And a member may not speak against your motion, but you can vote against it. Now, I would qualify that to say if you offered a motion and somebody offered an amendment that you don't agree with, you can vote against that amendment. But you can't put forth a motion and then turn around and vote against it. Okay. Questions?
Yeah. This is something that I'm pretty sure our rules are silent about, but our practice sometimes contradicts what you just laid out, which is that it occurs as a sort of like normal and human that the comments from members are effectively questions for the maker of the motion, who then winds up answering questions more than, and therefore speaking more than twice. Are you suggesting that that would be out of order?
Yeah,
Okay.
because if a member who makes the motion, after it's seconded and stated by the chair, the motion before you is, or the maker of the motion wishes to speak to the motion, say everything you have to say at that time to have people vote for or against it, so that people aren't asking, do you mean this and do you mean that, which can waste time. So in other words, be prepared with your speech supporting the motion that you're offering.
Yes. Well, the way I would think of it, and you maybe correct me if this interpretation is wrong, is that, if we have 5 minutes or 10 minutes, what we do with our time is our time. And so if we ask a question of another member, that's considered a part of our
That's part of
5
your
to 10.
debate time.
Yeah, part of our time, and not necessarily, just like with Congress, if you're questioning someone who's in the audience, that's part of your time.
Is that what your rules say, if you get to
It's
that, you can
silence.
question another?
Our rules do limit when when a council member can speak
And that
on the
includes
same
questioning.
subject.
Mhm.
And what is that rule?
That they can't speak twice until everybody's had an opportunity to
Okay.
speak.
Do we have a specific time set aside? 5 minutes, okay.
Okay, and that includes questioning another council member. That comes out of your time.
No,
That's the part that's silent.
That's the part that's silent, exactly.
That's it. Okay, next.
No, Clerk Mendoza has a question as well.
Oh, I'm sorry.
You have a question?
Yeah, and that's to each motion. Yeah, that's it. But that 5 minutes includes questioning another council member. That comes out of your time. Okay.
We got 5 minutes left before break.
In a minute, I'm going to tell you what I was told. Take as long as you want because you're last on the agenda, but we're doing okay. I think we can do it.
I mean,
Guidelines.
we have the opportunity, if you're willing to stay,
Yeah,
to
that's what I was,
incorporate this
that's
into
what I
our
was saying.
lunch
that
hour.
If you have questions, rather than leaving my phone number and answering questions when I may be off with another client, I'd rather answer them today. And then if anybody, you're free to, call on me at any time because it's something I brought up. But if we run 5 or 10 minutes over, I need to shut up when you tell me to. But if you have questions, I don't want to cut you off in the middle of it.
The
Okay?
technical assistance will be cut off at 12 because I have something else I need to do at 12.
Okay, but this will be done. Okay. Successful, when I said start on time, whether you have a quorum or not, as I said earlier, even if you don't have a quorum, call the meeting to order anyway. My experience has been people, if they know you're going to start late, they'll come late. If they know you're going to start on time, even if you don't have a quorum, but one is expected because of traffic or weather, talk about items that don't require action, like voting on them. And next time, they'll be on time because they know you're going to start without them. So don't get in the habit of starting late. Yes?
Can't do that.
Go ahead.
That was our practice until about 2 or 3 years ago, when I believe that there was a Attorney General opinion issued that, for instance, if we didn't quite have a quorum, we would discuss other matters at a committee.
Discuss other,
Right, but then our legal department explained to us that there was some new opinion from the Attorney General, I believe, that said we could do no business. We could not even call the meeting to order. And so we had to stop doing that. And maybe
Well, what
that-
is
maybe
the
that's changed.
definition of call the meeting to order? What is the definition of calling a meeting to order? Does that mean that you are voting on items, et cetera? I think that's what you need to define.
Right, well,
But
and
if-
that's, the question I have is, so we, with a couple of committees that we were on, because we had no quorum, we did not have the meeting.
Okay.
Yeah.
You didn't have the meeting because you didn't have a quorum, but if
Right.
you know that nobody's told you that they're not coming, and so-and-so is 10 minutes away, and that way you'll have a quorum, are you going to disband or talk about something else
No,
until?
we don't meet until the
Okay,
quorum
all right.
is- we don't-
Again, if that's your rule, you go by your rule.
So what's the rule, just so we have clarification? Because I've done both.
That's the council's decision.
But that, I'm just asking if we have clarification. If not, we could take it up.
So
at
my
another-
understanding under the Open Meetings Act, the mayor calls a meeting to order and there's a roll call. And if there's a roll call and there's not a quorum present, then according to what Councilmember Nguyen just talked about with the PAC, which I'm not aware of that ruling, you can't.
Crystal clear. I think council is pretty clearly defined where we, to Alderman Nguyen, on the committee level, whether it's a task force, special committee, or human services, I've seen it happen both ways. So I'm saying, do we have a clear defined for our committees?
We can talk about that offline because the
Okay.
rules require the committees to
Maybe
make their own
that's something
rules.
you all need to talk about.
Got it.
Because you have the
Yep.
Attorney General and then you have the parliamentary opinion. And as long as you're not voting on something, which can be challenged or declared null and void, then talk about anything else, but as long as you're not voting on anything, especially if you're expecting the quorum. But what I told the last client I dealt with, what if we don't? I said, why don't you send out a meeting notice ahead of time and have them, give them a deadline for responding. Then if you don't have a quorum, you cancel the meeting. Because you know ahead of time that there's not going to be a quorum.
And we do
We got 2 minutes.
Okay. Okay. At the end of that, that's when you make the decision to continue. Okay, this will go fast. Review and approve the agenda. We've covered that after the call and before the first item of business. So that's, I have addressed that under agenda. Exercise authority with tact and discretion. Refer to yourself, the mayor or the chair, whatever, not by first names. Vote only in the case of a tie. This is for the presider. Or if the vote is by ballot. If the vote is by ballot, again, follow your own rules if it's something. And if somebody moves to vote on an item by ballot, you can do that. Otherwise, it's a voice vote, okay? If I were a member of this council or a voting member who's not of the council, even if I was a parliamentarian, if I'm a member, I could vote by ballot because I've done it. Next. And remain impartial. Refrain from entering debate on a motion. You shouldn't unless it's some information you have that they need. But you don't enter the debate. And if you do, you need to assign the chair to somebody else until that question is settled. Okay, now, go on. We're almost done. Next slide. Okay, just showing, and I don't have to tell you folks this, you're public officials. Stand when presiding. You may be seated during the presentation. Clarify the business. This is why I said after every motion, before the vote, you are now voting on the motion as amended, the motion whatever. Tell people where they are. Clarify the business. Explain the meeting of call for the question, which means debate is ended. There's no more debate on this. And so moved is not a motion. I handed someone earlier, didn't I give you the motion form? Hold it up, because I said so moved is not a motion. If somebody wants to make a motion, then have them state the motion in full. What I often hear is somebody makes a suggestion, you say, would you put that in form of a motion? Somebody says so moved. So moved what? We don't even know what you're talking about. I gave somebody, it's around there somewhere, a motion form where, well, you can make your own. I move that we do so-and-so. You sign it, the seconder signs it, give it to you so you can read it. And you can keep that and just pass it around if you want to make up something like that. Okay, next. I think it's next or last one. Go ahead. Next slide. And always alternate. When people want to speak, alternate between the pros and cons so that it's not always the pros speaking and not the cons, etc. Expedite business. You have a consent calendar, because I mentioned that. And that, you know, I'm not even going to bring that up. You know what to do with that. Refer a matter to a committee. We already discussed that when you want to. And using general consent. The general consent is, if there's no objection, the minute's approved. If there's no objection, we'll do this. If there's no objection, we'll do that. Saves time. And clarify what's being voted on. Again, you can't repeat the motion before the assembly often enough, because in all their comments and so forth, they forget what they're voting on, so you got to remind them. Okay? And just remembering, take a proper vote. No's are always louder. When people object to something, they're going to say it louder than they do if they agree. Okay? So the no's, it's nasal, it's always louder. And when presiding over a large group, most groups now are using the little click you know, the electronic. Okay, and go on. There's only 9 of you, so we don't have to do that. Remember that the group is made up of people. There are 3 types. People who want to accomplish the agenda, other people who want to socialize. There are only 9 of you. You didn't come here to socialize. You came here to conduct the business of your wards in the city. And then the power seekers, most of those, that's why I said, please don't record this session, because most of the power seekers are the folks who come here with something to say that aren't on the council, okay? This is where most of the comments come from. So they get personal power, social power, etc. But just remember that the audience is made up of a group of people who may not have the same objective and goals as you do. Next. This is what I was talking about. There being no further business to come before this assembly, this meeting is adjourned. Thank you very much.
Which it in fact is not. But we will
Thank you
stand at
very
ease for
much.
lunch. Thank you so much, Ms. Bumba.
So, Councilmember Burns, because he's new to the game, he really wants to get this. He put forth a motion to skip lunch. No, I'm just kidding. I'm just kidding. So we will resume still at 12:30? Okay.
Thank you, Mayor Biss. So I was just going to give a quick overview of our committee structure. So many of you are familiar with this, but this is really handy in terms of just breaking out how things get to a city council agenda. So every 2 weeks when the city council meets, the order of business, as we talked about earlier when Joan was talking about the order of our operations, our city council rules say special orders are first on the agenda and then the consent agenda. Well, the consent agenda gets created because everything comes out of a committee. So everything that we do goes to a committee. Once it's been through a committee, then it comes to the city council agenda. The only exception to that is, of course, the special order of business. And special order businesses are typically the budget and occasionally CDBG items. It's meant to be a somewhat rare thing. Sometimes it's affordable housing related, sometimes it's climate action related, but typically using the committee structure ensures that there is enough time allotted for something to get enough research and staff time devoted to it to make sure that once it gets to council, it has been fully vetted, there's been public participation, and that it's something that we know would hold up in a court of law. So Administration of Public Works typically deals with any contracts that we're entering into, water and sewer, capital and infrastructure, planning and developments, all land use related. Human Services is anything related to police, health, social services, and youth. Rules Committee is obviously our city council rules and how we govern during our meetings. And then we have economic development, which is any grants that we might be giving out, special service areas, downtown Evanston. So anything that is typically in those categories will go to those committees and then will flow up to the city council. Can you skip to the next slide, please? Thank you. Sorry. All right, so we have a software that we use that creates the massive agenda that you get every couple of weeks. And our schedule for that is that we put items into the agenda. The staff enters the memo, any additional attachments, resolutions, ordinances, any kind of packet information. Those all get entered into the software by staff. And the due date for that is the Monday before the meeting. So all items for the meeting on the 24th will be due this coming Monday. And then that gives us a couple of days to, review the entire document and make sure that nothing is missing, that everything's been vetted, that we have our MWEB memos, like all of those different things that go into making this packet. It gives us a couple of days to review everything before our goal is to post the agenda on Wednesdays. Usually it ends up being Thursdays. Most of the time that's because we're still running our AP process, our checks that we're going to, accounts payable, any checks we're going to mail out to vendors. So we try to make our best effort to get our packets out on Wednesday, but it's typically Thursday. Things are going very badly if it's Friday. So I will always notify the council if our packet isn't going to make it out on Thursday, because that is the expectation that we've set for everybody. But like I said, it's a best effort to make Wednesday. It's typically Thursday, and we really don't want it to be Friday. Next slide, please. All right, so this is a fairly straightforward question that I get a lot. How does my item get onto an agenda? And how does your item get onto agenda is one of two ways. Either you're the chair of the committee and you add it to the agenda, working with the staff liaison to your committee. So if you're chair of, economic development and you have something that you want on the agenda, you're working with the chair of that committee to add that item to the agenda. And when you do this, I would ask that you just be mindful of staff's time. They're already working on agenda items, not just for this committee, potentially other committees as well. And everybody's trying to make sure that there's adequate time to research things and to get them on the agenda with a reasonable amount of time. So when we try not to add things to an agenda at the last minute unless there's a huge sense of urgency or some other reason that makes it necessary.
I've seen just in the past where someone is working directly with a staff person on a specific topic, and your expectation is, because I'll use economic development because that's happened a number of times, that in addition to your work with the staff, you also have to notify the chair if you ask it on. So just having that conversation with the staff person doesn't automatically mean that something is going to come on a committee agenda unless you're speaking directly to the chair simultaneously.
Thank you for adding that. I appreciate it. Yes, and what we're also constantly monitoring is how many items are on agendas, because we're trying to make sure that we run the meetings efficiently, that there's sufficient time for everything to get properly vetted, and that, we have an idea in mind of what's coming in the agenda down the road for like the next couple of months. And we're trying to be mindful of making sure that there's adequate time to discuss all of the various things that will come before you. And that's, part of that is just managing what is on each agenda. But there's some things that we don't really have control over, and sometimes those are dictated by RFP awards, things like that, or other things that have a built-in time frame. I think you had a
So I
question.
think we have Councilmember Nusma first and Reed second.
So for a council member to get something on a committee chair, on a committee agenda, the council member would speak with the committee chair, and then the committee chair is not the one with the Word document.
Go ahead.
If I can respond to that. So I think you see it, or I've seen it more with Human Services. I mean, with AP&W, a lot of just the structure of the committee agenda is pretty standard, and I'd say a large percent of that is staff-driven because it's tied into contracts and things that are time-sensitive. But Human Services, things come up with I see it more with our residents and situations with the police or other soft social work issues where you would invite an agency to speak at a certain time. Well, if you haven't spoken to the chair and you've only talked to the staff or that agency, then it makes it difficult for someone to come up during public comment and get the proper time that they deserve,
Right,
because
right.
it's a non-agenda item. So
But
that's
just
where I'm being more
the
specific.
mechanisms of the actual written agenda being constructed, the chair directs staff to create that document.
Works directly with staff in
Works directly with
partnership.
staff.
Right. Because if I will use Human Services, Councilmember Burns may have a specific issue that he wants, and so does Councilmember Reed. It could be the same thing, Kelly. So you're listening to all three, and you're trying to prioritize it along with the information that's coming.
But when it's my turn to chair the committee, I'm working with staff, and I say, okay, here's what our agenda is going to be, and they create the document.
Yes, and you'll also get calls from all of us as well. So it's a huge responsibility, and that's one of the major reasons why we don't have two chairs. So you wouldn't chair two committees just because of bandwidth, and we try to divide that up pretty evenly across the board.
And there are, I'm sorry.
Go ahead.
And there are items that are rolling along that are coming into the.
If you want to speak, please turn on your microphone.
And there are items that are long in process at a committee level, and so the chairpersonship may change, but that doesn't necessarily change where that item is in the trajectory of getting to the committee, or getting to the point where the committee will vote on it. There may be a lot of discussion at the committee over a number of meetings, and then something will have been produced by the staff that will to be acted on. So there's long timelines on certain committees.
Councilmember Reed, is your question on this topic as well? Yeah, go ahead.
I'm curious, Manager Storley, how do you and staff determine kind of the hierarchy of what's going to be worked on? So if there's a reference made to a committee or a, special order of business is placed, how do you rank what you work on first?
So typically,
what takes
we're
priority?
working in conjunction with each of the committee chairs to determine that relative priority. But if a referral is made at a council meeting during call of the boards or at any other point during the meeting, we log that. We've actually had a discussion about adding some kind of form so that we have some kind of repository for these referrals, so that we can get more specificity around them, because sometimes when they're made, there's not enough information about the referral in order to adequately address it at the next meeting. But usually if a referral is made at a call of the boards, we'll follow up with the council member later in the week and try to get more information about it. And then we'll look at what's in the queue and for the coming up agendas and see where we can fit it in. And then we're talking and having a conversation back with the person who made the referral to say, hey, this month's human services agenda is really packed. Do you mind if we put this on the next month? And if you say yes, then that's the way we do it. If you say, you know what, this is super timely and relevant, like I really feel like we got to try to move it up, I'll say, I'll see what I can do and see if there's any way we can rebalance the workload among the staff. So that's generally how it works. Did that answer your
So
question?
if council took a, action to place something on the agenda as a special order of business, that presumably because we took a legislative action to do that, that would, I think, prioritize that amongst, everything else. If the council voted as a legislative body and said, hey, we want this on the agenda, in this way for this day, I presume we have the capability within staff to meet that legislative direction of the council, correct?
So if you're talking about if the council decides, like it did last week, to vote to put something on as a special order of business, we haven't had that happen in years and years and years. But it is, like you said, a legislative action. And so I think it's helpful for everybody to understand what that means in terms of how it impacts what's coming on the next agenda. If the council votes to put a special order of business on the agenda for the next agenda, you're absolutely right. We have to put forth the effort to put that on. And so that means other things might get dropped off. And so there's not enough, because there's only, like I said, 4 days. If a council member makes a special order of business motion and it's approved by the body and it's got to get on the next agenda, there's 4 days of staff time that are going into that agenda item. And so everything has to be dropped. And in that 4 days, staff will put forth the best effort to make sure that we get enough research and enough, analysis done to put that on the agenda. But if we don't feel 100% great about how much we've been able to accomplish in those 4 days before that Monday deadline, to get the packet and stuff in, there may be a staff recommendation accompanying it that says, staff recommends we refer this to committee, or staff didn't have enough time to fully vet it, so we don't recommend you move forward with it, even though it's placed on the agenda for action. So that could be like what one possible outcome would be. But there is obviously, if an action has been taken and voted on, you're right, everything else would have to be dropped. And then other things that might have been on the agenda that other people might have put on the agenda would have to be dropped in order to make room to get that thing done.
Councilmember Braithwaite.
Thank you. And so there's a report that you will all receive on a weekly basis. It's the city manager's report. So I think, I don't know where we'll end up with that particular recommendation, clerk, that Councilman Reed made. But for future items, I think respectfully, and if they're citywide and not like ward specific or something that has a history, I would hope that we're more mindful of how we add special orders of business to the agenda. But under the normal circumstance, city managers' reports come out on a weekly basis. Those are things that I've found to be very useful. It tracks when the referral was made, which council meeting, and then you'll see like a normal progression of how it comes up on the council agenda. The key thing is, particularly for the public engagement, and I don't think we educate our residents enough, like the work takes place at the committee level. Like that's when you can engage in the back and forth and really solicit the input of whether you're residents, businesses, whatever special group, always takes place at the committee level before it bubbles up to the city council agenda. And that city council's report is always going to be our best tool to pay attention to what's moving. Because to wait until the Thursday, sometimes when you receive a packet, and I think for many of us, if you're working during the day, you don't open that thing up until like maybe Friday, do a cursory read on Saturday, and then you're doing a power read on Sunday, Monday. It's not enough time to be prepared to really engage in the deep and heavy issues. And so, Eric, I have another. Are we still doing newsy items for City Council? Is there a mechanism that can we possibly bring that particularly for our new members? So we've done this in the past. Again, everybody's going to be busy responding to your residents, working your personal life. Typically what we'll get is some type of ping that says these are the newsy items, like this is a hot issue that you may want to pay attention to. And that can be an issue coming from any of our individual wards or citywide. It's always helpful to know, like, hey, you may want to pay attention to this specific issue that's coming up on a Monday night's agenda. I think the last thing, or probably the most embarrassing thing that I've had happen to me is I'm trying to argue an issue and I haven't taken the time to read it in the packet. And so, again, it takes up a lot of time that we're educating council members when we've had that issue or when we have the details of the discussion that are in the packet. So if we can do that moving forward, I think that would be helpful as a good reminder to me and probably also everyone else.
Great. I have a question as well on this. So it's clear that we're saying that, and let's talk about committee, because that's what's on the screen. Committee agendas are populated in two ways. One is by referral, and one is at the discretion of the chair. So the chair has incoming information, which is referrals have been made by council members that automatically wind up on the committee agenda, though it sounds like with some discretion regarding when. Staff is providing feedback and input regarding their capacity and prioritization advice. And then various people, including perhaps the chair themselves, are like, hey, here's a thing that I'd like to see on the agenda. And there's a lot of tugging and pulling of different priorities that have to be balanced. Are there any limitations on the chair's power to determine how to resolve all that?
No.
Okay. Thanks. So let's go Councilmember Nguyen first and Ravel second.
Well, I think if there is a limitation, it's given by the staff to say, we just don't have the ability to get everything done that's on there. I mean, I view the chairmanship as not like a chairmanship in Congress because we rotate. So everyone takes a turn being the chair because it would just be too much work to actually not to have to take it on and do it all the time. So it's like everyone has a turn. So it's kind of self-policing in the sense that I think it's the funnel that other aldermen can come and talk to you by, but that funnel changes, every 6 months. So, and mostly it's, discussing with staff, okay, how will the meeting run? Does so-and-so know that they have 10 minutes they can make a presentation? Do we know anything more? What other information is necessary? Have you talked to this particular council member about what else they might want to have at that meeting? So it's the chair is the organizer, but I would not describe the chair as the control valve on what gets on. I mean, what the control aspect is what's the staff capable of doing?
Great. How much, because we have, so now Councilmember Braithwaite's going to go after Councilmember Ravel. How much more of this presentation is there, Erica?
This is it.
Great. So Councilmember Ravel and then Braithwaite, and then I'm going to call it so that the Corporation Council has time to give his presentation, and we also have time to do call of the wards before 1, which actually is impossible, but we're going to do our best.
Well, I was just going to mention that there are, of course, other really big items that come to a committee agenda I'm thinking particularly planning and development, because anything that comes from ZBA or the Plan Commission comes to that agenda, and that, that can derail all kinds of plans. And Human Services has certain things that come to that agenda just as a routine matter, and then ANPW, of course, a whole bunch of stuff. So anyway.
Great point. Councilmember Braithwaite?
I think we're beating this thing to death, but the other piece to remember is what happens in the committee, particularly in AP&W and P&D, has a trickle-down effect to city council. And so I don't make good decisions after 12 o'clock midnight, and I think we'll learn as things progress, and I think we'll speak and communicate to each other, especially as you start adding items, that it's just something that we're going to learn how to balance very effectively with the assistance of our staff. So I'll be mindful of time, and we can move forward.
I like to say, I like to go home the day that I came.
Yeah, I just wanted to make a motion to extend our time beyond 1 o'clock as needed. Because unless we're just going to pack up at 1, we're already going to approach that, so.
Is there a second?
Point of information, Mr. Mayor. I know that we're supposed to wrap up according to the agenda by 1, but it looks like it says 1:30 at the very top of the agenda.
Cool. In light of that, is there any second to the motion? Hearing none, the motion does not die, as we learned this morning, but failed to be born. And thank you, City Manager Storley. That was super helpful. Corporation Counsel Cummings.
Thank you, Mr. Mayor. Do you mind if I do the presentation from here, because I'm also working the tech?
I think we would insist upon it, in fact.
Okay. All righty. Good afternoon, everyone. Nicholas Cummings, Corporation Counsel for the City of Evanston. I'm going to give a brief overview of the Law Department, followed by a brief overview of important City Council rules. First, covering the Law Department. The Law Department is the primary legal advisor to you all. Each of the departments, the boards and commissions, we represent the city in litigation, whether it be we are suing someone or defending the city. We handle land acquisition, disposition, and assessments. Assessments being Evanston has this process by which, for example, everyone gets their alley redone. That usually requires an assessment of the people that share that alley. The department represents the city as a legal entity. It does not provide legal services to employees, individuals, or businesses. And there's a budget of approximately $500,000, most of which is salary and benefits. The primary responsibility of the Law Department is to the corporation. So if you are sued individually along with the city, the rules of conduct for attorneys require us to inform you of the potential conflict between you and the city, and you will have to sign a waiver in order to represent you. And this has come up a couple of times since I've been here in matters involving lawsuits with individual police officers, for example. We have to warn them of their rights, that there may be a potential conflict between you and the city, but you have to waive that conflict in order for us to represent you. Otherwise, the city will have to assign them different counsel. Here is the staff as of now. Ms. Friedland is a part-time attorney. She just notified us that she will be leaving at the end of the month. So you're going to have myself, Attorney Brian George, and Attorney Alexandra Ruggie. Our paralegal is Keena Robinson, and administrative lead is Lolita Thomas. I would just ask that you make me your primary contact, although Brian and Keena deal with liquor licensing and will have lots of interaction with you, particularly Mayor Biss, as the head of the Liquor Commission. I'd ask that you not necessarily directly contact them. Same with Alex and Brian. They may staff committees, boards, and commissions. I ask that you not necessarily contact the staff directly unless, of course, there's a specific project that they are assigned and working with you on, I should say. Some basic legal principles. The City Council does legislative functions only, and this is according to your own rules. It sets policy for the city, which is members of the community. It approves payment of all expenses, and there's one major adjudicative function, which is disciplining its own members. The city manager does executive functions, which is policy for the city in terms of the employees of the corporation. And there are immunities. Council members are entitled to immunity when engaged in the lawful business of the council. So all of your votes here, regardless of if they end up ending in discrimination are immune from action. There's also immunities covered by the Local Governmental and Governmental Employee Tort Immunity Act. I forgot a word there. And there's lastly qualified immunity for every public employee engaged in their job. In order to preserve these immunities, it's important that you follow advice of counsel. I will reiterate that and I think it came up earlier, I'm merely an advisor. It's up to you if you want to take my advice. However, there may be consequences to not following that advice. And if the advice is not followed, it creates a conflict with our office and will result in outside counsel being brought in to represent, whatever happens or defend whatever happens as a result. Some of the things that you might be asked as council members: how do members of the community file a property damage claim against the city? So the law department website has a link which allows members of the community to file a claim with the city. That claim is investigated by our office or our third-party administrator, and a determination of liability is made, and we make an offer of settlement to resolve the claim, or it's outright denied for one reason or another. The city's code is online as well, and the link is there, as well as a link to the city council rules. These will be helpful to you. And one thing I will say is that Evanston, even if the opinion might be different, is a very transparent city. A vast majority of the stuff that we have is available online without a specific FOIA request. So if it's not online, then it's still available, but I'd be surprised because a lot of stuff is online. Like sometimes we even get FOIA requests and they're asking for stuff and we just direct them to the website because it's already online. Okay, any questions about my department before I go on to city council rules?
A couple of comments, Nick. Welcome to the new position, and I think we're fortunate to have you. And in the past, a couple of things that I've seen with the legal department. Anytime you have a big idea, Major, it's always nice to, I think Nick is very good about you can pick up the phone and ask him anything. And I think that having you has been much better than we've had in the past, at least my experience. So I would encourage you, if you have a question, whether it's from a resident and you don't know, don't respond until you've at least picked up the phone and contacted somebody by legal. Someone will literally take the words that you say, and it can be later on used against the corporation. As we represent our residents, we're also responsible to our corporation. So keep that in mind. So me telling someone, yes, you can put that fence there without running it through will have consequences. Me telling someone, no, you can't open that up without having like a clear understanding has a lot of impact. So we have a wonderful legal department. I use them, and I would encourage our new members to reach out as well. That's it.
Councilmember Braithwaite brings up a good point, and it should be reiterated that my responsibility as corporation counsel and those who work in the law department is to the corporation. As elected officials, you have a responsibility to those who elected you as well as the corporation. Each of you is a fiduciary of the city. So you have to balance those responsibilities, and I certainly understand that. A lot of times in the conversations I had with the members of the last council, that discussion centered around those conflicts. But as Mayor Biss pointed out, I want to say at your very, very first meeting, when you act as the council, that's the city taking action. The city can't act without the council. So that's why it's imperative that you understand that you have both the responsibility to those who elected you as well as the corporation when every decision that you make. Are there any other questions to the law about the law department before we go to the council rules? All right. City council rules. So it came up a lot in the parliamentary procedure portion, so I'm going to highlight as many of them as possible. There are 28 city council rules, so I'm not going to go through all of them. I'm going to go through the ones you're going to deal with most likely. The city council rules take precedence over Robert's rules. The rule number 2 talks about the agenda and order of council meetings. It's actually in your rules how the agenda goes. So you've already set the agenda, but it's up to the mayor to determine the priority of business. So I believe typically our agenda has consent agenda for APW and P&D. If the mayor decides that P&D is going to go first instead of APW, that's within the mayor's purview according to the rules. It's also up to the mayor to run and control the meeting, make sure that there's order kept. The city manager is is who controls what goes onto the agenda for official council action. That's also in your rules. We talked about closed session earlier. Only topics specified in the vote can be discussed or considered, I should say, in closed session. You cannot take any final action on anything in closed session. So no votes on anything can happen in closed session. And anything discussed in closed session must be kept in strict confidence by those in attendance, according to your own rules. We've discussed committees. The rules outline the committees, and it should be noted that the city council rules apply to city council. They do not apply to the committees, except where enumerated. Okay, so in your city council rules, there talks about what a quorum of a committee is. That's literally the only rule in the city council rules that applies to the committees. So it's up to the committees, once you are assigned, that each committee needs to formulate its own rules. And I would highly recommend those get written. I believe ZBA and the Plan Commission have written rules that are published online. But absent any rules we learned today, you're going to go by Robert's Rules of Order. Okay. The conduct of members is controlled by rule number 10. Again, the mayor controls the meeting, and any council member who fails to comply with the rules or a code of ethics during a meeting may be censured or expelled by the council. That goes back to what we talked about, the ability of the city council to discipline its members. Questions of privilege are limited to cases where the member's integrity, character, or motives are assailed, questioned, or impugned. So we learned today in the parliamentary procedure, you can raise a question of privilege. According to your rules, the only questions of privilege that you can raise are these here. Rule 11, conflict of interest and abstentions to votes. Council members are expected to vote yea or nay on all matters, except in any matter which involves a direct personal pecuniary interest or conflict of interest. I'm always going to advise you, and I know I've spoken with at least one of you, maybe a couple of you, about this. I'm always going to advise you, if it appears to be a conflict, I'm going to advise you to abstain. And that's because, as I've learned since I've been here, you have very interested community members, and they will bring you before whatever body controls ethics. And even if the conduct was unethical, in order to protect the corporation and you, it's best to stay away from any behavior that even looks like it might violate the code of ethics, or at least looks like it's a conflict. The rules regarding debate on an issue, debate on the same topic is limited to 5 minutes per council member, except by consent of the majority, and consent is assumed if there is no objection by any council member or the mayor. So we learned during parliamentary procedure that silence can be consent. So this is the rule. If somebody goes over 5 minutes and there's no objection, then it's assumed that you're okay with them going over 5 minutes. And we already know that no council member may speak on the same subject until everyone has that opportunity to speak at least once.
I don't think the rules articulate this, but is the assumption here that each of those bites at the apple are limited by 5 minutes, or is the total limited by 5 minutes?
I think the assumption is that it's total limited by 5 minutes, but again, if there's silence by the majority, it can go on. And so you, as the chair of the body, get to limit that or enforce this provision, I should say. I think Rule 13 is redundant, but again, the mayor controls the meeting, and any council member who fails to comply with the rules may be censured or expelled by the council. Here are some motions that are enumerated in the rules. They may be a little different than Robert's rules, which is why they are spelled out differently. Motions must be seconded. All ordinances and authorizations to spend money require a roll call vote, and majority 5. So although there may be places in the rules, as was pointed out by the parliamentarian, where it's a majority of the quorum, this rule specifically says we can't spend money without 5 votes, period. So even if you have a majority of the quorum present, you can't pass an ordinance or any authorization to spend money without 5 votes.
Can you give, it doesn't happen, but that means we can pass it out of AP&W, but if we don't have 5 on city council, then it just stands. And I don't think we've ever had that situation, but that's probably the only reason that would trigger that.
In my short time here, meetings have just been held until we get a quorum.
Yeah.
So that rule is there, though, to protect the rights of the majority. You can't do certain things without a majority. A motion to table any matter is not debatable and requires a majority of the council members present in order to adopt it, and it must be tabled to a date certain. You guys discussed this earlier. Instead of being tabled, it probably should be to postpone. But that is what the rule is, as of now, is to any motion to table is not debatable, but it requires a majority of the council members present. Councilmember Newsma.
So I understand what tabling to a date certain means, but what would happen if you didn't know when you were going to have the answer to the question, and you didn't know if it was going to be June 12th or August 12th? What's the appropriate parliamentary maneuver in that?
So this is where the distinction comes between tabling and holding. So, and we'll talk about this very, very shortly. You cannot hold an item past one meeting, but you can table it, and this has actually happened since I've been here. You can table it to a future meeting. It comes up at that meeting. It's still not ready. You can table it again. There's no rule in your rules that limits the amount of time that the number of times that you can postpone or table a matter. But there is a rule according to the rules where you can't hold a matter beyond the next meeting. Okay, does that answer your question?
Yes, thank you.
A motion to call the question requires an affirmative vote of 2/3 unless one of the following motions is interposed: a motion to adjourn to a specific time, motion to recess, a motion raising a point of personal privilege. It talks about special orders of business, which we've went over several times, and I added this rule because I messed it up before in the last council. Any item other than a special order of business to be held over until the next regular council meeting at the request of 2 members. No vote is required to hold. A vote is required to overrule that hold, okay? But a special order of business cannot be held. That's really the point and I messed this up before, so I want to make sure I got it right this time. You can't hold a special order of business to the next meeting. Ordinances in Evanston require 2 readings, so no ordinance may be adopted in the same meeting as introduced, absent a motion to suspend the rules that is approved unanimously by the council. So any ordinance, and this sort of goes to items being placed on the agenda, and again, this is just my advice. Unless an item is on the agenda for legislative action, which is a resolution or an ordinance for introduction or action, it's for discussion, because the body can only take action, meaning voting on a resolution or voting on an ordinance. If it's an ordinance, it must be introduced at one meeting and then action taken on the next meeting. Ordinances require a majority, 5 votes, unless otherwise specified, which is Rule 26, and we'll get to that shortly. But again, ordinances, according to your own rules, require 5 votes. It cannot be a majority of the quorum. Mr. Mayor Biss?
Thanks. Yeah, and this is probably just my own ignorance. My understanding was that there are times when items appear on the agenda for introduction and action. What enables that?
So what happens is we are told by a member of the council, or the city manager asks if it can be done at the same meeting. And so what we'll do to the agenda is we'll say, Councilmember X requests this item be, for introduction and action. A lot of times that happens for things like increasing liquor licenses or something of that nature, or putting in new stop signs. At that point, the council is aware and the public is aware, because the agenda has been published, that instead of 2 readings, this one will be a single reading, at which point the motion will be made to suspend Rule 20.1 to allow for that item to be introduced and acted upon at the same meeting.
And that motion requires unanimous vote.
Correct. And if it doesn't, then it just gets introduced.
Thanks.
Any other questions about Rule 20? 20, I know it says 25. I think it's actually 20. Maybe it is 25. It's not 26. It's Rule 25. These are extraordinary votes. These are votes that require more than a majority. in order to pass. 3/4 of the council members then holding office. So that's 7 votes. Vacation of streets and alleys, passage of a map amendment when 30% of the property owners within 500 feet of the boundary of an area to be amended file a written protest with the city clerk. Passage of a unique use when 30% of the property owners within 1,000 feet file a written protest with the city clerk, or to amend the budget. 2/3 of the council members elected and holding office, so 6 votes. And this can get complicated in the event that someone vacates and we haven't appointed a replacement, but just keep in mind 6 votes. For the sale and lease of real property, purchase of goods and services over 20,000, passage of an ordinance over the veto of the mayor. And it's interesting, I believe your rules talk about the veto of the mayor being refusal to sign the ordinance. So it's not like a technical mechanism where he can make his veto known at the meeting. If you pass an ordinance 5-4, he refuses to sign it, it'll come back on the agenda because he refused to sign it as vetoed, and then you have to take action to override that veto by 2/3 vote.
Nick, can I ask a question? Because I scrolled down and it doesn't say, because we need the mayor as well as the clerk's signature.
Yes.
So it codifies the mayor, it doesn't say anything about the clerk, if I'm reading that correctly.
So according to state law, the clerk's signature is not necessary for it to be passed. It's only necessary for it to be evidence of action. So without the mayor's signature, it's not fully enacted.
Okay.
I have an asterisk by overrule the liquor commissioner and rejection of an application, as well as passage of modification of a site development. These are technically administrative bodies, so their actions are not appealable, for lack of a better way to describe it, to city council or any of its committees. So if someone has their liquor application rejected, it should go to the Circuit Court of Cook County instead of city council. But right now, it still goes to city council, and that's something that I hope to work on with my department and with your cooperation to amend the city code to make sure that we're doing all of this correctly. 2/3 of the council members present. Temporary suspension of any rule except 20.1. A roll call vote on a motion to call the question. A motion to overrule the request of 2 council members to hold a matter. A motion to reconsider made in the same meeting in which an original vote was taken. An expulsion of a council member for the remainder of the council meeting. So, again, that's 2/3 of the council members present at the meeting. That's when, those are the only items that require that. 3/4 of the corporate authorities, which is defined as the mayor and city council, is to appoint or remove the city manager. And unanimous votes to suspend the rules to allow for an ordinance introduced at a meeting to be enacted at the same meeting. Once again, there are 28 rules. This is just those that are most likely to come up most often. I am always available to discuss the rules with you if you have a question. As pointed out, it's really it's going to be the mayor as the chair of the meeting to ultimately make a decision in terms of the interpretation of the rules. Mine is just advice. So thank you.
Thank you. Are there any further questions? Councilmember Reed.
Corporation Counsel Cummings, would you mind talking, if you are prepared to, a bit about, because I think this is something that I've seen missed in the rules, committees, particularly how committee chairs are appointed, who has the authority to appoint committee chairs?
So committee chairs are selected within the Rules Committee itself. I'm trying to find here we go. It's under Rule 9, which talks about the committees, but the Rules Committee determines who chairs what committees, and how that rotation plays out. That's determined by the members. This body, each of them are members of the Rules Committee. So you guys make that decision.
For standing committees, and then for committees that don't report directly to council, can you?
The ad hoc committees may be appointed to consider specific items. The special committees of the aldermen can be composed of aldermen appointed by the council or the Rules Committee or by the mayor. special committees of aldermen, I'm sorry, the rules haven't been updated, so council members, I'm sorry. Special committees of council members and citizens of the city shall be appointed by council members, by the council, the rules committee, or by the mayor. Special committees appointed by the mayor, which I did not go over that particular rule, but there is a section under rule number 5 that talks about the mayoral appointments. Special committees appointed by the mayor with the advice and consent of city council can be composed entirely of committee members, and I believe the committee member, the committee itself is required to select their chair. And then except as provided in Rule 5.7, the chairs of those special committees shall be appointed by the mayor with the advice and consent of city council. All appointments of the above committees shall be with the advice and consent of council. So that's what our rules say to that point. And 5.7 does talk about committee chairs, which is within the mayor's authority.
Any further questions for the Corporation Council? Thank you very much for an extremely helpful presentation. And now we go to call of the wards. Councilmember Kelly.
Thank you. This is really a very informative morning. Thank you. May I make a referral?
Pursuant to the council rules, you sure can.
Okay, great. So with summer around the corner and in the spirit of promoting economic development in any and every way possible downtown, I'd like to refer to Human Services Committee to consider amending our code to create a variance process to allow dogs at the outdoor dining establishments that are interested. Our IDPH contacts have confirmed that that we don't need approval from them to proceed. And of course, the variance would provide evidence that the health hazards associated with dogs and outdoor dining establishments are mitigated in some way. Thank you.
Thank you. A point of order before we go on to Councilmember Braithwaite. Is this meeting being recorded?
It's my understanding it's being broadcast. I don't know if it's being recorded. I'd have to look at the
Zoom here.
All of our meetings are recorded.
Great. Okay. I just wanted to, perfect. So then, great. Councilmember Braithwaite.
Is that I just wanted to check and see what for our next meeting, sorry, before I make a referral or a suggestion, recommendation. All right. The city manager, Storley, just looking over this agenda for our next Saturday, can we talk about communication with councilmen regarding staff? When to communicate, how to communicate. One of the things that I've experienced just over the years is that now that we are in this seat, communication with staff changes in terms of like how we address them. And I think it would be important to go over that just in terms of times that are called, expectations for responding to council members. And I think that's basically it. And I didn't see that on the agenda. Thank you. And also just thanking all the members of the community that came out to our second ward meeting this Thursday. Thank you, Mr. Mayor.
Great suggestion. Thank you, Councilmember. Councilmember Wynn.
Well, I would like to request from the city manager that every single member of the council get a copy of the rules to be put in our desks so we could have them, the current rules. Other than that, no report.
Thank you. Councilmember Nusma.
I will amend Councilmember Wynn's request, and if we could include a table that we saw for the Roberts Rules of Orders, but in accordance with city rules. And that's it. Thank you.
Thank you. Councilmember Burns.
Yeah, first, have a Fifth Ward meeting Wednesday, May 19th, 7 p.m. You can, the link is provided on the city's website on the calendar. And then also wanted to make a few referrals. I think these are jurisdiction referrals to the Rules Committee, but one is to take a look at potentially consolidating our committees, repurposing them, creating bylaws, and possibly eliminating committees. I want to make some referrals to create new committees, but I think the first work is to look at consolidating, repurposing, et cetera. I would
Councilmember, can I just ask for clarification? Are you talking about the standing committees of the council or all boards, committees, and commissions?
I think all.
All boards, committees, and
Yes.
commissions? Okay, thank you.
Again, I think this is jurisdiction of rules, but want to take a look at how long we allow people to keep properties boarded up and the exceptions and exemptions to that. Again, I think that's a jurisdiction of rules. I'm not quite sure what committee works on that. Jurisdiction of rules, non-IDOT truck routes, I want to look at kind of how those are established and if we need to determine new truck routes, specifically ones that in the Fifth Ward. And then this one, again, I don't know where this goes, but as far to my knowledge, we don't have a healthy work environment complaint process. We have a one-pager with not a lot of words on it. So again, I don't know if that's, I'm sorry. Yeah, so that's another, Councilmember Reed is saying APNW, but again, I'm just not quite sure where these go. So is that rules?
I would just add, I forgot to mention this when I was going over referrals earlier. It's not necessary to define what committee your referral goes to. In fact, sometimes it's just easier if you make the referral about what you want the referral to be, and then staff will decide what committee it goes to.
Perfect.
So we'll work on that.
That is all. Thank you.
Thank you. Councilmember Ravel.
No report, Mr. Mayor.
Thank you. Councilmember Reed.
Yes, I want to announce and work with staff. I plan on having our first 8th Ward ward meeting on Saturday, May 22nd at 2:30 p.m. For residents. So we will have that virtually by Zoom. So we'll work with staff to get the newsletter out and invite 8th Warders to that and folks across the city. I would also like to make a few references. One, I'd like to make a reference to rules, preferably for the 24th, that we amend rules 18.11 and 18.12 to allow for potentially only the mayor to place special orders of business on the agenda unilaterally. I do not think that the city manager, as the city manager, should have the unilateral authority to place an item as a special order of business which would limit the rights of members to vote or hold an item. So I think that should be something that is left only to the legislative branch, which would be the mayor and the council. And I think the mayor potentially can retain that authority to unilaterally do that. I think that makes sense. I'd like to add also for the rules a reference for creating a new, as Council Cummings noted, our rules do delineate the orders of business. We do not have a section for new business, and I think we should add that so the city manager does have a route where they can add items that they see appropriate for consideration of the council without limiting the rights of the members to hold that item. So I think we should add a section for new business so the city manager has that authority. I'd also like to make a reference that we appoint our clerk as parliamentarian and that we provide the necessary and adequate funding and training for the clerk to get trained as a parliamentarian. And then lastly, I would like to make a reference to amend Rule 12.1 to allow for 10 minutes of debate per motion, which is more in line with Robert's Rules of Order. I think, limiting members to only 5 minutes and then just any member can cut you off by saying point of order. I think that's not enough time to have a real thorough debate. So I make that reference as well. That ends my report. Thank you.
Great, thank you. Well, I want to thank all the presenters, staff and external for a really helpful morning. I know I learned a lot. Thanks everyone for their time. Looking forward to next Saturday. And seeing no further business before us, the City Council stands adjourned.